Good afternoon, ladies and gentlemen, and welcome back to the second half of today's event. Before we proceed, we would like to remind everybody who has not registered to kindly register at the registration table located at the front. And don't forget to drop in your business card in the bowl that is next to the registration sheet. And on that note, we're moving on to the first of 3 panel discussions that we will have this afternoon. The first discussion will be on the topic, Advantages and Disadvantages of Arbitration in Sri Lanka. And it will be moderated by Dr. Harsha Cabral, President's Counsel, who is also former member of the ICC Court of Arbitration. And Dr. Cabral will be joined on stage by Mr. Shanil Fernando, who is a member of the Chartered Institute of Arbitrators and is also the chairman of ICC Sri Lanka, together with Ms. Himali Manatunga, who is the manager legal at Ceylon Bank. And they will be joined virtually by Mr. K. Muralipani, the managing partner of Joseph Tan Jude Benny LLP Singapore, Mr. Alex Anjou LLB and fellow of the Chartered Institute of Arbitrators, who is also an advocate and solicitor from Sarawak, Malaysia, and the representative of the ICC Young Arbitration and ADR Forum, Mr. Yasid Hiriburegama, who is also joining us virtually. I would like to kindly invite the panel to take the stage.
Well, good afternoon, and we have in this session the advantages and disadvantages of arbitration in Sri Lanka. We have, what's the time frame like? 1 hour session. And we would like the panelists as well as the participants to discuss certain matters that are coming under this particular head. And we have Mr. Muralipani from Singapore, Alex Sheh from Malaysia. Then we have Yasid Hiriburegama from Oslo, I believe. Finland, yeah. So welcome you all. There have a couple of questions that have been posed already. I think we have, the first question is, why has arbitration failed in Sri Lanka? Right? It's a very common topic. I think I briefly touched on when discussing disadvantages and advantages in arbitration in Sri Lanka vis-a-vis international arbitration. Now, you would know that most of the international arbitration centers are success stories. Now, whereas our institutional arbitrations are minimal, we have ICLP, which has, it becomes, I hope you know the difference between ad hoc arbitration and institutional arbitration. In an arbitration agreement, the dispute resolution settlement clause might just say dispute resolution by arbitration. Now that is an ad hoc clause. They have not decided how it is done, where it is done, what language, what rules, what law, etc., etc. If it's an institutional arbitration, you will have that extra note which would say it will be by arbitration, and the arbitration will be under the SIAC rules of arbitration. Seat of arbitration will be Singapore, and the substantive law would be, say, English law, so on and so forth. So the difference between ad hoc and institutional arbitration is very important when you think of major arbitrations. It may not matter that much for smaller arbitrations, but overall, institutional arbitrations, I mentioned about the well-known institutes in Sri Lanka. We have ICLP, Institute for the Development of Commercial Law and Practice, and now there is a new center, ICLP CCC, that is Commercial Chamber of Ceylon Chamber of Commerce, and they have started a ADR center that is now housed, which was recently started. It's housed at the Twin Towers in Colombo, and that has all the facilities. That's a fairly new one. I believe Vindhya is here. Vindhya was responsible in getting, trying to get all the port city agreements to have that particular clause. And that is a most welcome step, because all international players coming in, at least to the port city, will enter into that particular clause. So that is important because the facility that is offered at this ADR center in Colombo is state of the art. Whereas the other two, most of the other arbitrations are held in ICLP down Green Path and the National Arbitration Center in Vidyamavata. And though they are very common centers, well, still the facilities are to be upgraded. Right? Whereas the new one, ADR Center, has a more user-friendly, state-of-the-art facilities which we have to look for if we are to encourage international players to come into commercial arbitration in Sri Lanka. It started long time ago by the state, did not work, and it was not being used for a long time, and now it has been resurrected, and I hope there will be business if the commercial world gets going. Now, why has arbitration failed in Sri Lanka? I will just give you a couple of points and open it to the panel and the participants. In Sri Lanka, in my view, these are what I have mentioned in my book, I have given 10 points why it has failed. Because in my own experience in the 35 years in this particular field, first point is there is lack of case management. This is some drawback what we see in court cases also. No case management. In international arbitrations, first step of an arbitration is case management. Then there will be a order, right? Setting out the timelines, which we don't see that happening in Sri Lanka. Serious case management, that's why in the Indian Act, when they mentioned, I thought that was very good. And so, lack of case management, number one. That has to be introduced if we are to go forward. Timelines, how to do it, when to do it, filing, so on and so forth. Point number two is, in Sri Lanka, arbitrations are held only in the evenings. Now, this is a serious drawback, right? Arbitrations, well, the arbitrators and the council will have to sacrifice their court work. Come in the evening, we do arbitration for 1 hour, half an hour, 1.5 hours, is not going to make a difference. And earlier also I mentioned, you go abroad, you finish a huge arbitration in 1 week or 2 weeks, even big arbitrations can be finished. So this evening arbitration business has to stop in Sri Lanka if we are to move forward. Number 3 is lack of skilled staff and infrastructure that is provided in Sri Lanka in arbitration. I mentioned a couple of places where we have the seat of arbitration is Colombo, and we don't have proper secretarial staff, we don't have proper infrastructure, right? Starting from parking and all the other things. So you need that type of, you can't expect international players to come and, go into that level. Very, very unsatisfactory secretarial services are provided. Whereas if people who have gone overseas to do international arbitrations would know, I'm sure my colleagues from the Aegis department, senior members would know how it is done, right? You get the script then and there. If you want four pages in 1 page, that also you can get, maybe at a price, because long years ago, it was about 25 years ago, there was an arbitration where Lord Mustill himself was arbitrator. Mustill and Boyd is #1 book on arbitration. Lord Mustill came for an arbitration to Colombo. It was the Asian Hotels Corporation, Oberoi arbitration. And secretarial services were provided by Clifford Chance. They charged a heavy fee, but the secretarial services were absolutely fantastic, right? So if you're looking at high-level arbitrations, you need that expertise, infrastructure. Now, if you follow arbitrations in countries like Dubai, Singapore, London, Paris, you have whatever you say is on the screen, everybody can follow it. Scripts are then and there, you can get it. In the evening, yet sometimes after 2 weeks, you can't get the proceedings, like our court cases. Even after 6 months, you can't get proceedings, right? The next day, you can't start the trial because the proceedings are not there, or the stenographer has fallen ill, right? So that you can't do that in commercial arbitration. So point number 4 is a lot of time spent on petty leasing, hire purchase arbitrations. When we introduced commercial arbitrations, we didn't envisage that. They must have a separate small place to handle those, because most of the arbitration centers in Sri Lanka is inundated with the smaller petty, leasing and hire purchase arbitration. The parties don't know whether they are coming or going. All ex parte, one-sided, and they don't want to do away with that because that brings them money to keep them going. Then the 5th point is court procedure into arbitration. Now this is another bad practice by our legal fraternity. Whether practicing lawyers or retired judges, they have the tendency to make it another courthouse. One day for issues, one day for settling issues, and nothing called issues in arbitration, right? Admissions and issues. So that is a very bad practice. It's not a courthouse. If you go and see international arbitrations, totally different to a courthouse. Very casual, you do it nicely, right? We don't expect that court atmosphere to be brought into arbitration. That's another drawback. 6th point is long dates given in arbitration in Sri Lanka, right? We give, because long dates are given, because the council's diary, because if you get very senior president's council, their diaries are full. Even to get that 1 hour in the evening, you won't be able to get, right? Their diaries are full. Then the center diaries are full. If you do an arbitration today, your next date would be maybe October, if you're lucky, or November, right? Then one party will file a motion and say their counsel is unable to attend, and it goes to next year, February. God only knows what will happen in February 2024. Then they will say, oh, curfew election, and it'll go down to some 3 other months. So you can't do arbitrations like that. So long dates given should be a barrier. That's why that case management is important, where I know exactly when to do, how to do, so on and so forth. Then 7th point is lack of control by arbitrators. This is something I touched upon in my speech also. Arbitrators lack control. Now this is what we see, the international players in arbitration would know, how the arbitrators control proceedings. You must have perfect control in the arbitration. You can't let the council control proceedings. Here what happens is, the council takes control in most of the arbitrations. Arbitrators think that they are under obligation to council to get their next arbitration. Now you've got to get that mentality away. However big the council is, you must stick to your own rules and regulations and the time frame, so that discipline by the arbitrators in the proceedings is a must. If you don't do that, the arbitration will be go haywire. 8th point is procedural delays in courts, especially in the High Court. I mentioned there are 63 places where you mentioned the court in the Arbitration Act 11 of 1995. So every trip to the High Court, you will be spending a year or 2 to enforce minimum 6 months to 1 year, right? You're not reopening the arbitration, but that trip to that courthouse, send summons out, get the parties in, filing papers, normal court procedure is there. So lost delays, you get stuck in that pipeline. So procedural delays is there. That is not what is meant by commercial arbitration in developed jurisdictions. That is why they run to Singapore. Because Singapore, it doesn't happen. They have a timeline for everything. You know exactly when you go how much you will spend for the arbitration, how long it will take, how long it will take to enforce it, right? My friend would know exactly. You can give a guarantee to the client. This will end on such and such a date. Very first day itself, the diary is set down. Then, point number 9. There is a beautiful section in the Arbitration Act number 11 of 1995. Section 32, subsection 2. Right? Now that section says, when an application is made to set aside an award, the court may ask the party to deposit the sum of that award that has been awarded. Only problem is it says may. You know, in labor tribunal appeals, if you go up to an appeal, you have to deposit that money. So that will leave all the deadwood away. So unwanted applications will not be made to the High Court. Unfortunately, 32(2) is not used by any of our courts, right? So that you weed out unwanted applications to set aside. So if you don't have a good case, you would not go to set aside the award. That is there in the Act. No one uses it. When this morning I was talking to Dr. Kanagiswaran about this section, he said, please tell everyone, at least to make an application under 32(2), so that unwanted applications may not be made. It's beautiful. So I was telling him, in vain, we should have made that word shall without making it may. If you want to challenge that, okay, deposit that amount. Then, 10th point, the final point I want to say is scarcity of judgments on arbitration. For students, the academia, for the corporate world, to know about arbitration, right? Very few judgments recorded. Now, during COVID, I put out another book on arbitration law reports, 1895 to 2020, in one volume. From 1895 to 2020. This was during COVID, I had nothing to do, I did this. Now for company law, I have 4 volumes. Intellectual property, I have 3 volumes. But this has only 1 volume. Scarcity of judgments. So you can see, very rarely you get good judgments from our courthouses. Now without having proper judgments, the law will not develop. The judge-made law is absolutely important for anyone to go forward. Without having good judgments, in fact today in the morning in the Supreme Court, my Guru Dr. Kanagiswaran on the other side and I was on this side, we settled the case which started in 2006, IP case. And when it was settled, I told the Chief Justice, sorry to say that this was a good case to have got a good judgment. We are starved of judgments, right? But unfortunately, when it is settled, that is not recorded, you don't know. So I told my juniors to keep the written submissions intact. Because this is a very lovely case where Dr. Kanagiswaran's client wanted to get exclusivity to the lion mark, right? This is regarding a beer case. I appeared for a Singapore client, and this was his appeal. Finally, they settled it. And so a judgment like that for the student, to develop arbitration, you need judgments. We hardly get very good judgments, right? They are all settled, or very rarely you get good judgments. So you can't, law will not develop. Singapore, India for that matter. What a lot of judgments you all get. When a new act comes, how many books are written? Here no one writes books. This is my book on arbitration. Is the only complete book on arbitration in Sri Lanka. And other one is Dr. Kanagiswaran's book, a compilation of articles. He and S.S. Vijayaratne. No other book to read. So if you want to read, develop arbitration, a lot of people spoke to me how to do arbitration, how to read good books like Redfern on arbitration, Mastill and Boyd on arbitration, Markand, the Indian book. There are so many books on arbitration, commercial arbitration, right? So, and there are a whole lot of new books on new developments. Now, your arbitration, they are not going to sit and do arbitration. They'll be do online arbitrations. Because you don't need that amount of oral evidence in arbitration, because the domain name arbitrations, WIPO arbitrations, they do online. Statement of claim is online. Statement of defense is online. Statement of reply is online. Witness statements online, written submissions online, award is online. So within 6 months you can finish any big arbitration. If you want evidence, okay, that also you can make affidavit evidence online, cross affidavits. Here we cross-examine the same witness for how many years? Sometimes years and years. By one day today, next day is September, next day is February next year, right? He has forgotten what he said earlier. So these are areas we got to seriously think if we want to upgrade our commercial arbitration in Sri Lanka. And if you want to add something, all right. Yeah.
Yeah, I think, Ruan, there is a presentation coming from Singapore, Mr. Mural, isn't it? Can you play it? And then we'll let Mr. Dr. Harsha Cabral ask the questions from them. Can you?
Yeah, because the next point is how does international arbitration work? So that's a good eye opener for all the Sri Lankan.
Yeah. Mr. Murali's presentation.
Shall I proceed, Mr.
Yeah,
Chairman?
Murali, go ahead.
Yes, thank you. Right here. So, as you can see from the first slide, the presentation is on this fairly narrow point called the law of the arbitration agreement. The first slide. Now, I think all of us are familiar as lawyers or even as commercial parties, we are very familiar with a clause of this nature called the governing law clause, whereby it provides for the law that will govern the party's substantive rights under a contract. We turn to the next slide. And this also should be a fairly familiar clause. It's a dispute resolution clause providing for litigation. In other words, that any disputes arising under the contract will be decided by the courts of a particular jurisdiction. The next slide sets out, again, a fairly familiar clause called, and this is the arbitration clause, which is more pertinent to us in this conference. And it provides, and this is a template ICC arbitration clause, and it provides for disputes to be resolved by ICC arbitration. Now, if we go to the next slide, this is I dare say, a less familiar clause. This is a clause providing for a law to particularly govern the agreement to arbitrate. Now, in my practice and doing arbitration, I frankly only come across this clause very few times. It is not a commonly seen clause, and it's not provided for in most of the template clauses provided by the major arbitration institutions. What does this clause mean? If we move to the next slide, it's got three key functions. We begin firstly with the doctrine of separability. As we all know, jurisprudentially, an arbitration agreement is considered separate from the main contract. That is why when the main contract is found to be void, the arbitration agreement can still survive and require disputes to be dealt with by arbitration. And it is accepted that an arbitration agreement can have a different governing law from the main contract. And it is this law of the arbitration agreement that governs issues such as the validity of the arbitration agreement and the arbitrability of disputes, whether a particular dispute is subject to arbitration. So the question really arises, as this clause is rarely seen in most arbitration agreements or in most contracts that provide the resolution of disputes by way of arbitration. So what happens when no choice is made? The next slide will tell you what the courts have done. Right? When there is no express choice to the law governing the arbitration agreement, the courts will imply a choice. And there are only two choices, right? The choice is either the governing law of the main contract or the law of the seat. Now, what we have had is a historic uncertainty where courts have taken alternating positions. Some courts have chosen and said that the law of the arbitration agreement impliedly is the law of the seat, and others have said it should be the law of the main contract. The rationale behind this was that in applying the law of the seat, some courts felt that this was going against party autonomy, which one of the key features of arbitration. Where similarly, they felt that other courts felt applying the law of the main contract created a procedural uncertainty as to how we're going to cross the border between the law of the seat and a different law of the main contract. Nonetheless, today we have a bit more certainty thanks to a number of cases, 2 Singapore cases and 1 UK case, which essentially provides that the starting point to imply is the law of the main contract, or the governing law of the main contract. So, having reached that position, you might be asking, so what's the problem and why is this fellow talking about this point when it's all been cleared up? Now, there is a potential consequence that arises out of this now judicial approach of implying the law of the main contract to be the law of the arbitration agreement. And the next slide will show you an example of what can go wrong. I've taken the approach in arbitration of anonymizing, so you can see these are all not real places. Now, let us assume we have an agreement that is governed by the laws of the People's Republic of Wakanda. And that contract also provides that any dispute will be settled under the rules of arbitration, of ICC arbitration, by 3 arbitrators. And it also provides the seat of the arbitration shall be Asgard and the language of the arbitration shall be Asgardian. So quite a complete looking clause. And the commercial parties to the contract will have a legitimate business expectation, which is any dispute arising out of the contract will be resolved by arbitration in Asgard, in Asgardian language, by 3 arbitrators. But if we follow the philosophy now that's being adopted, that if a dispute arises out of the arbitration clause, meaning one party challenges the arbitration clause, what is the law that's going to apply to determine the validity of the arbitration clause? As I mentioned, the approach now is to imply, if parties have not made a choice, that the law governing the arbitration clause is also the law of the main contract. So in our particular example, it's going to be Wakandan law. Now, could I ask for the slide to be moved on, please, to the next slide? Should be slide number 9 now. Yes. So here we have a situation where Wakandan law is being applied to determine the validity of the arbitration clause. And as we know, different jurisdictions have different approaches to arbitration clauses, and also whether a particular dispute is subject to arbitration. For example, as I understand, claims relating to company oppression or minority shareholder oppression is not arbitrable in India, but it is arbitrable in Singapore. So you have certain differences of approach in various across jurisdictions. So now what happens if Wakandan law holds that the subject matter of the dispute is not arbitrable or the arbitration clause is void? Basically, the arbitration clause falls away and any dispute now will fall to be resolved by the court of Wakanda. So 180-degree turn, which resulting in an unexpected outcome for the commercial parties, that instead of the dispute being resolved by 3 arbitrators under ICC rules, in Asgard, using the Asgardian language, suddenly their disputes are going to be resolved by the court of Wakanda. So if we can move to the last slide, second last slide, sorry. So in conclusion, this not choosing the law of the arbitration clause can have a very profound effect. Now, I'll be the first to say that this effect is not going to be commonplace because of some commonality in approaches across jurisdictions, but the potential does exist. And the potential does exist for a particular party to an agreement to get a horrible shock, right? Where disputes are being resolved in a manner completely unenvisaged. So my first takeaway would be that there should be some awareness of this point, especially when the most template clauses, as I mentioned, do not provide for a choice of the law of the arbitration agreement. And the second takeaway should be that counsel advising parties to a commercial agreement should consider this point and consider also whether to make an express choice of the law of the arbitration agreement. That concludes my presentation. Thank you.
Thank you, Murali. So, in a nutshell, what Murali suggested was he touched on the importance of the arbitration clause. What are the essential features that ought to be there in an arbitration clause, starting from arbitrability. And in a good arbitration clause, it will be very specifically set down what the institute is. Now, ICC, he took up the example of ICC. ICC is considered as the hallmark of arbitration in the international arena. Now, I think Mr. Phillips should have mentioned he's the current member in the ICC panel in Paris. And there you see how beautifully it is practiced. Now, in an institutional arbitration, that is very, very important. The most crucial part is the arbitration, a specific defined arbitration clause, taking into consideration the arbitrability of the dispute, and then the substantive law that applies. It may be sometimes different from the substantive law that applies to the main contract, but if parties agree, they can have the same main contract law as well as the substantive law for the dispute. And then comes the procedural law that will come along with the seat of arbitration and the procedure that comes along with it. Right. Now, these features he touched on because that is the starting point of any proper commercial arbitration. So prior to entering into a contract, these are the things that you got to think of. That is why in Sri Lanka, I must say, a lot of people enter into a contract without knowing the consequences. If you have a clear-cut arbitration clause, which sets down very clearly what the substantive law is, what the procedural law is, what the seat of arbitration is, and what the language is, and it'll be very clear. I mean, if anyone is interested, just log into ICC arbitration. You'll get loads of information about that. Log into SIAC arbitration. Log into HKIAC, London Court of International Arbitration. All the rules are there. You know exactly how long will it take, what your cost would be, what would be the arbitrator's cost, what would be the institutional cost. All that is defined there. Even in Sri Lanka, you have our own ones. But ICC can be used anywhere in the world. ICC arbitration, Shanil will tell you, that with the headquarters in Paris, we have all over the world arbitrations. So there's all international major arbitrations can be seen under the ICC umbrella. So that is what Murali just suggested. And if both of my panel members can add something to it, we can ask the panelists. Right. So we'll get Mr. Alex also to do that presentation from Malaysia and open the dialogue. Yes,
hello,
Alex.
Everyone.
Hi.
Hello. Yes, it is 4:45 here in Malaysia now. How's everyone there?
Hi. Go ahead.
Yeah, I wish to thank ICC Sri Lanka and also its chairman, Mr. Shanil, for inviting me to speak in this conference today. Thank you very much. Now, I understand that the topic today is about arbitration, pros and cons of arbitration in Sri Lanka. I'll be talking about how to become an arbitrator in Malaysia So at the end of the day, you can actually compare the practice of arbitration in Sri Lanka and Malaysia. So hopefully someday I can see someone from Sri Lanka here practicing in Malaysia for arbitration. Now I will share my screen. All right. So the law of arbitration is governed by Arbitration Act 2005 in Malaysia. How to become an arbitrator in Malaysia? If you are appointed and agreed by both parties, then you can be appointed as an arbitrator in a case. That is pursuant to Section 13 of the Arbitration Act. In respect of the numbers of arbitrators, parties are free to determine the number of arbitrators. What if parties fail to decide? If parties fail to decide, then in respect of international arbitration, there shall be 3 arbitrators. In respect of domestic arbitration, there shall consist of a single arbitrator. Now, for international arbitration, each party will appoint an arbitrator, and then both of the arbitrator will appoint the third presiding arbitrator. In the case of where both arbitrators cannot agree to an appointment of a third arbitrator, then either party may apply to Asian International Arbitration Center for such appointment. In respect of domestic arbitration, a single arbitrator will be appointed, and in the event parties cannot agree on a single arbitrator, then AAC, short term for Asian International Arbitration Center, would be the appointing body. Section 13 says that anyone can be an arbitrator regardless of his or her nationality. Asian Institute of Arbitration Center, AAC, would be the sole appointing authority in Malaysia. What if AAC fails to appoint an arbitrator or fails to act in certain matter? The High Court of Malaysia would be the supervisory body. In respect of consideration in appointment of arbitrator, the court or AIAC would have a look at the qualification required, other consideration, and in respect of international arbitration, the court will look at appointing an arbitrator of a nationality other than those of the parties. You can refer to Section 13, Sub 8 of the Arbitration Act. Who would be eligible to be empaneled with AAC as an arbitrator? Person between 30 to 70 years old, sufficient education, minimum 10 years of post-qualified experience in arbitration, fellowship or similar accreditations from professional membership or organization in arbitration, and someone who is not a bankrupt nor convicted of any criminal offense within or outside of Malaysia. How to apply to be empaneled with AIAC? You can go to the AIC website. You can go to the panelist registration form. Once appointed, you are bound by the policy and AIAC code of conduct. And then what will happen after your empanelment? AIAC will try to appoint you as an arbitrator on a rotation basis. Now, I know arbitrator would be eagerly want to know about the fee that you will earn in respect of an arbitration matter. You can go to the AIAC fee calculator. For example, if the dispute is roughly around 215,000, your arbitrator fee in respect of an international arbitration would be 73,000 USD. In respect of domestic arbitration, similar amount, your fee will be roughly around 12,000 USD. Right. In respect of enforcement of arbitration made in Malaysia, the law says that arbitration award made in Malaysia or from a foreign state shall be recognized as binding and enforceable. Arbitrator could not be liable if he act in good faith. That would be section 47. Section 48 says that the arbitration center or its members are immune from liability unless they act in bad faith. All right. This presentation is actually endorsed by Asian Institute of Arbitration Center. Just a brief introduction. They opened in 1992. In 2021, they have their new arbitration rules and up until today. The director of AAC now is Datuk Sundra Raju. Way forward, they are looking to improve existing AIAC standard form of contract and to do more ADR training in Malaysia. Well, that's all from me today. Thank you.
Thank you, Alex. So the Alex's purview on the Malaysian situation is about the Malaysian Arbitration Act, how it operates, and the AIAC rules regarding arbitration vis-a-vis its application. So he highlighted the major issues on an institutional arbitration, how it works, as taking into consideration the Arbitration Act of Malaysia and the rules as per AIAC, Asian International Arbitration Corporation. That's the Malaysian framework of the international and domestic arbitrations, but somewhat similar to our local Arbitration Act 11 of 1995 and the respective rules we have. Now, we have Mr. Yasit Imbure Gama also. Yasit, do you want to add anything to the previous presentations?
Hello, sir. Can I comment on the drawbacks of arbitration in Sri Lanka?
Very well.
Continue from there. Yeah. First of all, I would like to thank ICC Sri Lanka and Chairperson Shanil Fernando for inviting me for the conference and especially to share, especially to be a panelist with my guru, Dr. Cabral. So going back to the question, we have a starting point because we have recognized our weaknesses as like Dr. Cabral pointed out, and we can start from there. One of the main drawbacks, I would say, is that we are not adapted to the changing world of the international arbitration. Like for example, we need to make our the arbitration legal framework pro-arbitration friendly. Like for example, when the third-party funding came to international arbitration, we are still struggling with adapting to recognize third-party funding in Sri Lanka because of the Gaming Act, and it contradicts with the third-party funding in arbitration. And also, I would like to highlight the fruits of being a leading arbitration seat, because Sweden was mentioned before, the International Arbitration Survey in 2018 conducted a survey, and they have found that the Sweden, being a leading arbitration seat, they have profited around 800 million per year because of leading seat. So we have learned from the Swedish expertise, but we are a long way from there. And if as young arbitrators or as young counsels if we diligently work on arbitration, especially on the cost and timing. We can, and also adapting the legal changes pro arbitration. We have a potential to go there. That's what I believe. And as a young arbitrator, I would like to suggest the ICC Sri Lanka to open a forum for young arbitrators to discuss about the potential issues and make visibility for young arbitrators, because they have plenty of time. Then, like one of the weaknesses just mentioned, that arbitration is only held after court proceedings. It will not be a problem if there's more available arbitrators or young arbitrators are there, and the cost of reputation can also be lower. And yes, that's what are the main things I can mention about the first arbitration drawbacks in Sri Lanka. But I'm hoping that we can go forward.
Thank you, Asit. Thank you very much. I would now first ask Shanil to make some comments, and then overall after that to Himali.
Yeah. Hello. Yes, I think. So I think we actually, from this arbitration, the follow through, what we want to do is to see where the ICC can play a better role in developing arbitrators or training. And I think in the morning session, Dr. Harsha was not there. Most of the speakers are talking about training and so on. So in fact, Justice Javadan also was saying that the practical training side should be given. There are theory training that is being given by ICLP and so on. Maybe that we could start a 2-day session with some of the big practitioners we have here and some of the judges and the ADS department people. We are working on that. I've spoken to Tejas some time back on that as well. So we might have a 2 or 3 day training on that. And also to see in the future, the ICC Sri Lanka has in fact registered the Colombo International Arbitration Center, Facilitation Center, which they were trying to start up. So I think within the next few years or within the next few months, something of that nature will start coming in with the funding that is going to come in from overseas. So thank you.
Very keen on adding arbitration clauses for their agreement, like more than 50 million or 100 million, like that. Yeah, when we don't have tangible securities like property mortgages or something. But when we go into the arbitration, we found that the first factor is the cost factor. It was very expensive on point of view of the banks. And secondly, it was more or less than a court procedure. Like we have to file the statement of claim, objections, and raise issues, as Dr. Will correctly said. And again, we have to file that traditional affidavits, and it was like a mini courthouse, but at the expense of litigants. So that was the main reason bank withdrew from arbitration procedure. In fact, now there was a shocking news recently and on newspapers that banks' non-performing advances portfolio of the whole commercial bank is 1.6 trillion as at 31st March 2023. So then most probably it would be a huge impact in the economy. So banks are desperate to do recoveries and find alternative methods rather than court procedure to come for a settlement with the customer and get their loans settled. So there is a huge potential for the commercial banks, but those issues with their still. And sometimes when we even go for the procedures, arbitration procedure, we held up calling postal witnesses because they do not respond. Especially the government institutions, they are not aware about the arbitration. So we'll have to go to the High Court and get summon issued for them. So as Doctor said, it will not take another 1 year. So those are the problems that we face as banks. So since there is a huge potential requirement for the banks as well, so if you can stretch your as ICC to facilitate the requirement of the bank, especially to cut down the time factor and cost factor, there would be banks would again consider adding arbitration clauses to their agreement and come for arbitration. Thank you.
Now, I would like to open the dialogue where you can have some questions. ICC has been always there to assist the process of arbitration. And we have had several instances where international arbitrations have been held in Sri Lanka under the ICC rules. So ICC guidelines, everything, you don't have to worry too much. You can just log into the ICC webpage and get all the details. So if there are any questions, you can start a dialogue between the panel and the participants.
In Colombo, in the Western Province, basically it's been taken in the commercial High Court. So High Court is basically a criminal jurisdiction, the commercial High Court is civil jurisdiction. How the court change like that?
You know, when the act came into operation in 1995, right, the law was modeled for the most senior High Court, right? So at that time, Commercial High Court was not there. High Court Special Provisions Act number 10 of 1996 created the Commercial High Court. Only in 1996, the Commercial High Court was created. So thereafter, by an administrative move, all arbitration matters were shifted to the Commercial High Court. Now you don't go to the criminal court. You go to the Commercial High Court for enforcement, setting aside any other application under 11 of 1995. You go to the Commercial High Court. Now, to make it easier for the outstation practitioners, it was made, Kandy and Jaffna were made, the high courts were brought in, but there aren't many applications made there because the commercial hub is the Western Province. So all Commercial High Court has a specific court now, which deals with commercial arbitration matters. So that court is inundated with arbitration matters like setting aside, enforcement, other several matters come under the Act. So they all go to the Commercial High Court now. It's not the criminal court.
That's in Colombo.
Yeah.
Or the Western Province. But outstations, you go to High Court, is it?
Yeah, but outstation, there aren't many cases. Though we created, that is to accommodate people rather than coming to Colombo, to Kandy, and can't even mention about anything happening in Kandy and Jaffna. Because arbitration, commercial hub is the Western Province. Your second question was?
Yes, second question was, Doctor, basically, now Section 5, more than it's an ambiguity, it's just a misconception people have it, that when there is an arbitration clause, that you can't go to court. But what is it? If the both parties agree without going for arbitration to go to court, you can go to court.
It's not a misconception. If you read my book, there's a separate chapter on Section 5.
With the introduction of the Act, a lot of companies, as Nimali mentioned, a lot of companies took out the arbitration clause.
No,
that is compulsory to go for arbitration.
That's not correct.
Yes, that's what I say.
Section 5, we got it from UNCITRAL model law, right? And from other jurisdictions. If that is party autonomy. If parties have agreed to go to court, go to arbitration, then you're prevented from taking the same matter to courts. Now, that is basic law of Section 5 says, well, court is ousted, right? It's an ouster clause. If parties have agreed to go to arbitration, you have to go to arbitration. Behind your one's back, you can't go to courts. But there are 6 exceptions to Section 5. So it does not make it a total ouster. It's a partial ouster. One is Section 5, if you read carefully, it says the court has no jurisdiction if the other party objects, right? There may be instances when you go to court, the other party might not object, thinking that court is a better forum to resolve it rather than going to arbitration. That is one, exception one. Exception two is, in urgent matters, though there is an arbitration clause, though both parties have agreed to go to arbitration, you know, fraudulently, other man is going to encash your bank guarantee. So if you wait to give notice of arbitration, all that, and start arbitration and get interim relief from the arbitrator, by that time your bank guarantee is gone. In such situations, you can go to court and say, my substantive relief, I will go to arbitration. But until such time, give me relief to protect my bank guarantee. There are judgments given by courts, all recorded in the Sri Lankan courts, where interim measures can be obtained by arbitration. There's the famous Bhatia Santush case also, right? But you can't ask for substantive relief from court. Substantive relief, both parties have agreed to go to arbitration. That's the second one. Third one is, in the arbitration clause itself, parties have said parties are free to go to court to get interim injunctive relief. You have protected that right. So if section 5 is there, still parties are reserved that right. Point number 4 is, under oppression and mismanagement under the Companies Act, you can override an arbitration clause. There's Indian authority, there's Sri Lankan authority, Justice Vimalachandra's judgment. Even if there's an arbitration clause, there's a famous Aitken Spence case reported, right? You can still go to courts under 224 and 225, oppression mismanagement. Fifth one is, by Roman Dutch law, there is improvements done to property and things like that. That fact is not covered in the arbitration clause. Under the common law, you can get relief from a court of law. That's the fifth point. Sixth point is, though there is an arbitration clause, there is a dispute that comes not within that perimeter, though between the both parties, that matter can go to arbitration, to a court of law. So there are 6 exceptions.
Can you explain the sixth one again?
Sixth one is, there is you have an arbitration agreement, but in the process, there is another agreement, another breach that has occurred, which doesn't fall under that particular clause. Then parties can go to court and say, well, we have an arbitration. But all these cases, you have to divulge the arbitration clause. Right? You go to utmost good faith, you ask for relief.
Doctor, there is one more question which I want to ask you. Now, we have a celebrity case, Scott versus Avery, and that is mentioned in the Hotel Galaxy versus Mercantile Hotels case. Is that case still applicable in Sri Lanka with the arbitration act coming in?
That was our old law. That is why Section 5 comes in. Section 5 subsumes Scott versus Avery cause.
How about the Mercantile Galaxy case then? That's all not applicable now. Right. Thank you, Doctor.
There's one particular question someone asked. How much time do we have? Can go for 10 minutes. Yeah, go ahead.
Whilst the arbitration matter going on, one party found one of the arbitrator and the other party found in liquor bar. What action can take? One of the arbitrator with the first party, one party found one of the arbitrator with the second other party member found in liquor bar.
Right.
What they can do?
So you can take it up with the arbitral tribunal itself, saying that you are not fit and proper and that you will be biased. And in such situations, the tribunal can take a call or the arbitrator might step down, failing which If that doesn't happen, there is procedure laid down in the Act itself. You can make an application to the High Court saying that the arbitrator is not fit to continue in this arbitration, and you can replace it. That is permitted in our Arbitration Act 11 of 1995. Any other questions? Mr. Rajapaksa, in general, you have good questions. He's one of the young arbitrators. There was someone mentioned about getting young blood into this. Definitely, we must do that. Get the young lawyers, young engineers, young architects as counsel for arbitration, as well as arbitrators in the panel, whether it's sole arbitrator or tripartite panel. Yes.
The Bar Association Law Reforms Committee is currently working on amendments for the
No,
Arbitration
what
Act.
happened was a new act was drafted, right? In Sri Lanka, you know, when regime changes, sometimes they don't proceed. So maybe the fate of that old draft would have been that. So I don't see that floating around anymore. So, but that doesn't mean that there should be tinkering done to the act. There should be. One important point I want to share with you on the arbitration field, what is the advantage of arbitration, is enforcement, right? You can chase your assets. That's the beauty of arbitration. Go to now, say, if you get an arbitral award in Germany, you can enforce it here. Same way you get an arbitration award in here, you can enforce it in China or whatever other country. I'll give an example. India is here. India, if I was in my chamber at that time, about 15 years ago, Sri Lanka Cricket entered into an international agreement with WSG Nimbus, a Singapore company. That is for their TV rights. And at that time, we were looking after the interest of Sri Lanka Cricket, and other side party insisted that they want an arbitration clause, Singapore International SIAC arbitration, seat of arbitration Singapore, substantive law, English law. So we collected the money, all that initial money. Then 1 year later, went into difficulty, and we ended up in arbitration. Arbitration was in Singapore, and we lost the arbitration. And we had to pay $5 million US to WSG Nimbus. By that time, Vindhya had left my chambers, and she was senior legal manager to Sri Lanka Cricket. And they sought to enforce it in the High Court of Colombo, in Malaysia, in Jamaica, and in London, 4 places. Because Asian Cricket Council was in Malaysia, they were trying to collect it in Malaysia. We had played cricket in England, and we were getting some money from Lords, and they were chasing that. And we had played cricket with the West Indies, and we were getting some money from Jamaica. We chased that. Ultimately, they settled it in Malaysia. India had to do a lot of trips to Malaysia to settle that. And we paid $5 million in staggered payments. Sri Lanka is very, I mean, if you ask the Aegis department, you would know how many arbitrations we have lost, international arbitrations, starting from hedging to all the others. We have won a very few, right? And you are handling another one, Express Pearl, right? Let's hope and pray that we'll get some more money to Sri Lanka on those. Unfortunately, Sri Lanka's problem is our documentation is very poor. All these international players who come to do construction work in Sri Lanka, whether it's Chinese, Japanese, British, or anyone, they bring with them the script writers. Their job is to write notes. That meeting, this meeting, site meeting, we had at 4 o'clock, 5 o'clock, where you agree to do this, that, and the other. We don't record it that much. So when you go to arbitration 3 years later or 5 years later, we have a serious problem in documentation. Whereas all those, now your construction people, engineers know, right? Especially when foreign construction people come here, whether it's Southern Expressway or any other highway, they bring with them a separate team to take down notes, right? Like the Liana Mahathir's job, they keep on writing. We refer to the meeting we had with you yesterday. You agree to do 1, 2, 3, 4, 5. and smuggle a few things which we didn't agree also. Right? And then 5 years later, we can't say, no, we didn't agree. So any other questions? I think we are time up and no questions. Okay, then thank you very much. We'll close our session for now. I think you all have a load of sessions to go on. Two more. Okay, all the best. Rest of the evening will be fine. Thank you.
Thank you to our panelists for that enlightening conversation. Our second panel discussion will be on the topic, a new trend in dispute resolution and mediation. But before we continue, ladies and gentlemen, may I please direct your attention to the screen, because we have a WhatsApp number which we have included in case anybody does have questions. We encourage you to WhatsApp your questions to us during the sessions so that we can take them up with the panel once the discussions are over. And on that note, we're moving on to the second panel discussion, which will be moderated by Mr. Dinal Phillips, President's Counsel, who is a member of the ICC International Court of Arbitration. He will be joined by President's Counsel, Mr. Chandana Patabendi, Ms. Himali Urugodawatta, who is Director Legal of BOI Sri Lanka and the President of ACL Sri Lanka. They will also be joined by Mr. Navin Pereira, the Assistant Vice President and Group Chief Legal Officer at Aitken Spence PLC, Mr. Roshan Madarasinghe, who is the Director, Contract Administration for Marga Engineering Private Limited, Ms. Vindhya Veerasekara, Director, Legal and Corporate Affairs, Colombo Port City Economic Commission, and Mr. Anand Majmuja, who is an advocate at Anand Majmuja and Associates from India. We kindly invite the panel to take their seats.
Right. Good afternoon, everybody. We won't waste too much time because we already had a 1 hour, 1.5 hour session with my colleague Harsha. So, and I'm sure it's tea time now in most offices. So, my topic is a new trend in dispute resolution mediation, but I do not propose to speak too long on mediation, what's going on, because it's a new area that, I mean, it's been there for a very, very long time in Sri Lanka, long before the Portuguese came to Sri Lanka. But this was there, the old kings used to hold this mediation between parties, etc., etc. And then thereafter, they had the Samatha Mandalas that coming in. But very recently, Dhara Vijaytilaka, the former secretary of the Ministry of Justice, has been a pet project to start mediation. I remember doing several seminars with Dhara many years ago, and mediation was her pet subject. And she's galvanized, I think, believe the ICLP to start a special new mediation center at the World Trade Center office, I think, and a new act is also being coming to force. I think that'll be there. But before we go on, I would like to ask our guest from India, Anand, I've got several questions from participants through WhatsApp messages, which I've heard. So I'll ask Anand, first of all, tell us about his experience in India as a course of mediation, because we all know what happens here in Sri Lanka. Let's get an Indian perspective of it straight away.
Yes, thank you. See, in India, we have pre-trial mediation. India introduced the Commercial Courts Act during the year 2016, and thereafter, it was observed that there were many disputes which are capable of being resolved by way of a mediation. It has now been made mandatory that every suit, before it is registered as a suit, parties are required to approach the mediation center. All courts in India, majority of the courts have state-of-the-art mediation centers, and the mediation center is headed by the judicial officer. One of the judge will be assigned to that center, the lawyers are identified to act as mediator in those mediation rooms, and all matters before they are registered as a commercial litigation, the parties have to mandatorily approach the mediation center. So this is at district level, this is at high court level, and our high court has also established a mediation center with same procedure is followed. Even pending proceedings are also referred at times, when the court believes that or court feels that that this dispute can be resolved by way of a mediation, then in between also the parties may be referred to mediation. So mediation is currently, becoming a very, very popular mechanism to resolve dispute amicably in the course of proceedings and before the proceedings actually commence. Thank you.
Anand, just to interrupt you on that, at the mediation center, lawyers are allowed to appear on behalf of their clients?
See, basically, as I said, mediation center is headed by the judicial officer, and below that judicial officer, the mediators are appointed. Mediators are local lawyers. Local lawyers, they discourage, the lawyers representing the parties, and they basically lawyers are not encouraged to enter, and unless if there is some complex issue involved, which only a lawyer can explain to the mediator. Except in those cases, in most of the cases, lawyers are discouraged to enter the mediation room, and to it is left to the parties only, and the mediator will intervene and will try to resolve the controversy.
So essentially, you have the mediator seated there, the party is before him, and that's all.
Parties, only both parties and mediator, they will be within the conference room, and then the mediator would try to resolve the dispute.
Because lawyers probably create more chaos than clarity.
Not really. You see, lawyer, sometimes, when the matters are referred, they are generally referred by consent of the lawyers or parties. And the lawyers, they are required to fill up the form, and then that is how it is referred. So, yes, so the experience has been that it is by that time, probably parties have lost patience also, lost money also. And see, there are reasons and reasons why parties would change their mind and they become softer.
Thank you, Anand. Well, the buzzword in today's context in business circles everywhere is port city, port city, port city. In fact, all I can say is, being a resident of Colombo and Colombo 3, that spoils my view of Golface completely. But anyway, this question is directed at India. What is the scope of arbitration within the port city resolution regime, and what agreements has Port City Economic Commission made to resolve disputes of parties licensed to business with the Port City Authority?
Hello. Yeah. So thank you for that question, Dina. So the Colombo Port City Economic Commission Act requires the Commission to facilitate the establishment of an International Commercial Dispute Resolution Center. This is statutorily required. And the Colombo Port City Economic Commission, with the help of the government, has set up the Commercial Dispute Resolution Center at the World Trade Center, which is a state-of-the-art facility. And statute-wise, what our act requires is that an authorized person, I may want to tell what an authorized person is, a person who wants to engage in business in and from the area of authority of the Colombo Port City has to make an application to the Commission, who then reviews the application and then issues a license and an authorized person agreement. This authorized person's agreement mandatorily contains an arbitration clause. Actually, what it is an alternate dispute resolution clause, thereby any dispute between the Commission and the authorized person, or authorized person's employee and the Commission, even an occupier or a person who has purchased a property in the port city, disputes with the Commission is referred to this arbitration center. Now, this arbitration center, like I said, is a state-of-the-art arbitration center, and we can use any person, not just a port city authorized person, but any person in Colombo, in Sri Lanka, in region, can use this arbitration center under the ICC rules, UNCITRAL rules, with the seat of Colombo as a arbitrate as long as it is stated in the arbitration clause. Does that answer your question, Dina?
Yes.
Okay, thank you.
Is there now, if you listen earlier, you are saying that the ICC are in a position to conduct an arbitration in Sinhala or Tamil. Now, will your center be able to carry out that kind of arbitration even to do that?
Yes, of course, mediation, conciliation, all those facilities are set up. And we have the International ADR Center that is managing this commercial dispute resolution set up by the Commission and the government. And you have transcription, immediate transcription, all the facilities are set up. So you just need to go and use it. And actually it's very cost effective. You to have arbitration rules, even SIAC, ICC, UNCITRAL, but with the seat of arbitration in Colombo. Thank you. Yes.
Go ahead. Thank you, Dina. I'm Chandana Liana Patamedi. There is this, I want to add something to about the BOI, dispute resolution clause in international investment law issues. In that, the United Nations level, there is a Commission on International Trade Law. So in that, they have very recently passed a resolution. They're going to consider it at the October meeting. I also got it on the internet because I received these newsletters. They're going to set up a working advisory center to advise such clients who would have state to investor disputes. So this is not a new area, but this is an emerging area for mediation. Other than the arbitration is a compulsory that is there in almost all these by law. But even for commercial mediation, the UN level, they are going to set up an advisory center. They're going to employ lawyers. They're going to get to the members and also to non-members. They're going to give their services. So this particular area of law, the international investment law, is an area where anybody can master. So I think because Linda she was senior to me at the Masters International Trade Law. Now she's into international investment law. So these are the areas where, as young lawyers, as established lawyers, as lawyers who are going to retire from the companies and set up practices, you can always get familiar with these clauses and know that there is this, even the ICC website, if you go through, if you go to the Commission on International Trade Law on the UN, you will find out all these material available to you to help. So that this is not magic, but specialization, I think Dinal knows that, like Dr. Harsha Kabra, there are law firms. Specialization is very important. So whatever the subject that you are into, specialization, so that it will give you a right even after retirement from the working as a in-house counsel, you will get that work. So be familiar with these particular area other than your company's particular legislation. That's all I want to say.
Vidya, let me put you on a spot here. Now, all well and good having a brand new center, passing wonderful new laws, but the implementation ultimately we find is that any proceeding is there when the agents taking it down, then next time you spend hours correcting the proceedings. Now, have you got any equipment to deal from voice to data?
Denalius, we have equipment set up there, which will give you immediate transcription of the proceedings. So that answers your question. So that's what I'm inviting everyone. Please go. It's at the 22nd floor of the World Trade Center. Have a look for yourself and see how well equipped you have an asset there waiting to be used instead of having different locations.
Right. Thank you, Vidya, for that vote of confidence, etc., and giving us a positive jab in the arm for that. And my next question is to Naveen. Now that Vidya has set up this wonderful new center, how does the business community look at things?
So from my point of view, I just take a practical example is that we need to have faith in the system. And obviously, I mean, if we are to go to her center, we have to have a mediation clause or an arbitration clause in our contracts. That is the starting point. So the parties must agree that first they will go in for mediation, if at all, and then maybe arbitration, and then finally maybe to litigation if neither of these options work. But we need to have faith that the system will work. So we need the support of, the arbitration centers, maybe the judiciary, the lawyers, and we need to make sure that it works and it must be proven.
What is the support and etc.? It's a little vague.
So we'll have to do like a test run. I mean, I haven't, the mediation and all that is not that popular from what I know, unless, someone can correct me, of course. But, commercial mediation, I haven't heard very much of unless it's settled at the start itself between the companies.
I call Dara the midwife of mediation now. So let's see how that goes. Chandran, have anything to add to that?
Yeah. Sorry, one more thing is that I came across a case in Singapore where that was somewhere in March 2023. That was the High Court of Singapore, where there was a construction agreement. The case is Max Engineering Works PTE Limited versus PQ Builders PTE Limited. Now, in that construction agreement, there was a clause for mediation. First, you go in for mediation, and then if that doesn't work, then you go in for arbitration. So one party said you have to go straight for arbitration and not mediation. But the High Court felt that mediation should be tried first. So that was a point where the Singapore High Court said that specific performance needs to be carried out first. So for me, that is the sort of support that, commercial mediation and all that needs. So, we all have to start somewhere. So we need to get it going, and I'm sure India will definitely help with a new arbitration center. Personally, I have been there. It is state of the art.
Does that mean that you knock out the arbitrators out, so without work?
No, not at all. Not at all. Everyone must be encouraged to use the system properly. Everyone must use the system properly, not for their own good. That is also there. Thank you.
May I add something? Because the whole purpose of this seminar is to not only to emphasize on the arbitration, it's also about mediation as well. That is why this session is centered around that, named like that. Because, recently, permit me to say this, because ICC works also very closely with the USAID. USAID very recently signed an agreement or a MOU with 8 big companies to get them to enter into mediation contract when they are into commercial contracts. So that shows the significance of this area. And like international organizations are also helping the business community to do that. So Naveen just said about from the business lawyers' business point of view that there should be a mediation agreement. Yes, that is what even the ICC is trying to do this by having this type of seminars, and this is what USAID also trying to have by getting the companies to enter into agreement, so that training would be done to them to have their in-house training. But at the same time, he spoke about the lawyers, from the business point of view. From the point of lawyers, are the lawyers going to be out of work? No. Certainly, we have 24,000 lawyers, 1,400 lawyers every year, 900 last month, next month again, another 700. I know exactly that is the amount. So, but still, we are going to have work because the young lawyers and the others, if they really form into partnerships or law firms or specialize in their subject, they will also get into, other than the arbitration, as an arbitrator or a counsel or running a center. Mediation is another field where you can help from the beginning, from the clauses to the preparation of papers, evidence, and at the same time, permit me to say this, Dinal. It is, I'm quoting from the Dr. A.R.B. Amarsingh's book, Professional Ethics and Responsibilities of Lawyers. He speaks very high of the lawyer because lawyers, I'm sorry, there are non-lawyers, but I'm talking about lawyers. Lawyers are for particular, they get a particular intellectual training and they're at a higher level. And at the same time, they are not just to litigate in courts. Arbitration has not failed. I don't agree with that. This mediation and other ordinary dispute resolution methods are coming because at different level, there should be different ways to solve issues or to negotiate and solve issues. So that is why these are coming, different names: mediation, conciliation, arbitration, court-assisted arbitration, adjudication, like that. So that lawyers' prime duty is to see, not to chase their client into litigation, to see what best methods are available to adjudicate the issues. So that is very clearly spelled out by Dr. A.R.B. Amarasinghe when he speaks about lawyers' ethics and responsibilities. So I think if you wish to, you can go through that pages, from pages 441 onwards. He speaks volumes about lawyers' duties as to encourage people to not to litigate, and also that is also as a last resort, and at the same time as to encourage people to go for arbitration or mediation. Thank you.
Now, I've been politically very incorrect because I've been only concentrating on the right side. I've not been doing left wing. So this question is rated by Roshan. With so many youngsters around here, this question is for you. Digitalization of dispute resolution and the use and promotion of online process for DR, including arbitration, mediation, and the use of blockchain and smart contracts. Pardon my ignorance, but what the devil is blockchain? Anyway.
Thank you for raising that question towards me. Actually, what I think we have been discussing about mediation and even alternative dispute resolution involves quite lots of, I represent construction industry, so that means, of course, lots of records, lots of documents, lot of contracts, hundreds of pages of documents. So the new technology towards what I think we should aspire to, not only to have online arbitrations, online hearings, and online submissions, which we also lack seriously in Sri Lanka. In construction sector, throughout COVID period, we somehow managed to, we have a specialized dispute resolution method called adjudication. So through COVID, we managed to hold quite a lot of adjudications through online. So submissions were all made online and just a few hearings. And then it was concluded, which was really helpful.
How do you go about an adjudication, as you said?
So adjudication is a bit of or dispute boards is a quite unique dispute resolution process. It's unique to construction sector. It's quite, I would say, not as structured as arbitration because there's no act or anything. It's more, it comes through the contract, but it's very quick because the industry as such, the projects are very, very short. We're talking 18 to 24 months project, and we need resolutions within 84, very short period of time. Quite rough justice, but we get the answer fast.
So will there be a architect or contractor or quantity surveyor hearing this or structural engineer and the adjudicating parties on each side, or how does that work?
There are qualified professionals representing all sorts of professions like architects, engineers, adjudicating both sides. There are set rules. The attractive part is very, very fast. Even in those, we are finding it very difficult to move it towards more like a digital platform. The submissions are all still on paper base. So that's what we said. This new technology, I think some of you may be aware of blockchain technology, which is revolving around cryptocurrency, but it can be used for smart contracts. So any changes, any submissions can happen real time. So that's, I feel, something in future we should.
Can you explain to some of us what this
It is
smart contracts is? And
it's somewhat complicated. I don't know, come from the construction industry. Maybe ICC can get some professional who can advise on this, and then we can get on. I have read about it, but it is a bit of a complicated technique. So.
We'll come to you in a minute. We'll come to the questions later. We'll finish this. And third-party funding, do you have anything to say about that?
Yeah, since this is what we have given is about new trends in ADR, which we found we are also involved in quite a lot of domestic and international, few international arbitrations. This is in Sri Lanka, it might not be a, it is quite a new development, but in other countries, it's some sort of a funding because of everybody is talking about the cost involved in arbitration, especially in international arbitration, is that you can look for a financier to fund your dispute. So that's what you call a third party. You have disputing parties and you go for a third party. So they will assess your dispute, I mean, from the claims point of view, what it called, eligibility and the receivability of the claim, and they will fund it. So it has been gaining momentum in quite a lot of jurisdictions. I saw in India, it has gained quite a few. There are quite a lot of conflict of interest things to be resolved as if someone else is funding your dispute. But ICC also has published quite a lot of literature on that. So I'm not sure whether it's, but it is an emerging trend.
Someone in the third-party contract means a provision ethics. Third-party contracts, funding. Third-party funding, where a third party finances you for your arbitration.
Sorry, I didn't. Sorry, I think we have to only represent the clients, right? So under those circumstances, I don't know about that third party. I'm sorry, I will not. I decline to answer. Yes. Yeah.
They say champati and etc. That's not true.
Yeah.
The emerging trend now, you find a large financier to finance your, because these are large claims.
In Sri Lanka, it is at the moment, no, can only.
Yes. That's why I thought let the Aegis department take cognizance of that and move it in some way. I know, but unless they bring that in, we won't be able to move in the matter as we misuse here. And right, let's move on to our extreme left. She's not a leftist, but our mighty atom here. So now, can you tell us what the new trends in ADR and dispute resolution and the importance of mediation as an ADR mechanism as far as the BOI is concerned?
When you talk about dispute resolution, we have to look at litigation, mediation, conciliation, negotiation, adjudication, and arbitration. The importance of if you take ADR, then you get other than the non-litigation, all the others, that is conciliation, negotiation, mediation, adjudication, and arbitration. When it comes to mediation, mediation is a facilitated, negotiated settlement facilitated by a third-party mediator, which the mediator helps the two parties to come to amicable settlement. And that also helps in keeping the relationship. It's a non-adversarial mechanism. So going for mediation in an existing, if you take the POI, if it's an existing investor, if you also have mediation, then while having the relationship, because if you go for arbitration, which is an adversarial nature, So what happens is the relation, it might affect the relationship. So we need to have mediation preceding the arbitration as well.
I thought arbitrations are less adversarial than being in court.
Yeah, it's less adversarial than in court, but then I think now it has become more adversarial, maybe little bit less than the court system.
So maybe the
Party
arbitrators must have control of the proceedings.
Yeah, party autonomy is there. So mediation, if you go in for mediation, preceding, anyway, the Arbitration Act also provides for mediation in terms of Article Section 14. And if you go for mediation, then that is, you might be able to settle it before going for arbitration. Maybe certain things, when you go for mediation, certain aspects of it might have to be referred for arbitration. So a combination of mediation and arbitration is the future.
Am I gathering that visiting their new contracts?
Unlike the Port City Act, BOI Act, it's not mandatory that we have to go for arbitration because what the Act says is that all disputes have to be referred for ICCSL unless otherwise agreed between the parties. And what our clause refers to is the dispute resolution clause refers to arbitration, and also we have to think of introducing the rules as well as where it should be administered so that there is clarity, as well as institutionalized arbitration is much better than ad hoc, and also the mediation to precede arbitration so that we will have a win-win situation at the end of the day.
So you will be having an arbitration clause or mediation clause plus an arbitration clause.
Arbitration clause is already there. So the administration, because now the Port City, the arbitration center is there. So the administration of a local, I think what the previously what happened was, like, if you refer to any rules, then that rules may be administered by a center, not in Sri Lanka. That may be very not be very cost effective. But if you refer to the administration by a particular arbitration center, that may be very cost effective for a government organization.
I think an investor, assuming somebody comes in, pumps in millions of dollars into this country, he would like a proper structured arbitration rather than this ad hoc basis of going and, 2 hours in the afternoon or 1.5 hours and then postponement for 3 months, etc. Won't he be like to have he won't like to be under a leaky umbrella to protect the investment.
So for that, we have to, we used to have the arbitration rules, and also now we recently, but we signed, we had the arbitration center as well as the rules for the arbitration center of the which is at the 22nd floor. So what happens is we have to think of the future as well as the new trends, how we incorporate that into the investment agreement so that we can be in par with the rest of the world.
I'm glad to hear that. So will that be cost effective?
It all depends, because if you also put mediation, maybe we may be able to settle it before going for arbitration, and also timelines. If you have the rules, then you can fix the time and the cost can be fixed. So we have to think positively, I suppose. Dina.
As Naveen said, we must trust the system. We must trust the system.
Yeah.
System.
To trust the system, I think one is we need training, which the ICC could provide for the corporate sector as well as for the rest of the people who use the system, so that we will be in par with other jurisdictions.
Right. Thank you. I see several bankers here. I have a question for you all. You all can help us out in this?
Does mediation help you out to resolve all your NPLs?
Question from the legal office of the Port City. That is, ma'am, you said you have introduced arbitration to Port City now. So what is considered as the seat of arbitration and what is considered as the governing law that I would like to know?
Okay, so the Act states that any dispute that arises, as I said earlier, between the authorized person and the commission, an employee of the authorized person and the commission, or an occupier, a lessee of property, has to be settled by an arbitration or alternate dispute resolution in the Port City. Now the WTC setup we have done is an interim arrangement because the Act permits us until 2026 we can stay, any authorized person can sit outside and still enjoy the benefits until the infrastructure is come up. So to answer your question, the seat of arbitration has to be within the area of the Port City of Sri Lanka. Now the law, what you require is it the substantive law you're asking, or is it the rules of arbitration?
Rules of arbitration.
So rules of arbitration, currently we have set up the IADRC, but that does not prevent anyone else. Say, this is just for the Colombo Port City, but anybody in Sri Lanka or in the region can use ICC rules of Paris or UNCITRAL rules and have the seat of arbitration in Colombo. The center we have set up is with all the responsibilities and functions of the IADRC is fully equipped to handle administering any rules of ADR processes. I hope I answered your question, ma'am.
Yes, ma'am. Thank you.
Do we have any more questions for the panel before we close for tea? No. On that note, I'd like to thank the panelists for taking the time to speak to us today. Welcome back, ladies and gentlemen, to the last panel discussion for today. Before we continue, just a quick reminder about your business cards, which we would love to accept because the ICC Sri Lanka we're trying to put together a register full of adjudicators, lawyers, and arbitrators, and it would be helpful both to you and to the ICC Sri Lanka if you could share your business card or drop a message onto their Facebook page or contact them through their email addresses in order to receive more information about entering your name into the registers. And we also have a WhatsApp number which is on the screen behind me, and you can use that number to send any questions or clarifications that you might have for the last panel discussion, so we can take it up once the discussions have been concluded. And on that note, we're going to move into the final panel discussion, which will be on the new trends in international arbitration and mediation. And this will be moderated by President's Counsel, Ms. Viveka Siriwardana, who is also the Additional Solicitor General for the AG's Department, Sri Lanka. And she will be joined by our international guest, Mr. Tejas Chauhan, who is Regional Director for South Asia ICC Dispute Resolution Services, Mr. Anuradha Tilakaratna, Engineer and Project Manager for the Morogoro Hydropower Project of the Ceylon Electricity Board, and Ms. Daini Kiriwattudua, who is the Legal Director for the Urban Development Authority. They will also be joined by Ms. Chandi Dialvis, Legal Officer and Board Secretary for Construction Industry Development Authority, Mr. S.M.P. Surya Bandara, the Senior Engineer, Road Development Authority and Arbitration Lecturer in Arbitration and Contract Management. And joining us virtually will be Mr. Anil Chandragoth, who is the co-head of ECG Practice RHT Law Asia LLP, Singapore. We also have Mrs. Santabala Padbendi from the AG's department, who will also be joining in on the panel discussion.
A very good evening to all of you. Thank you for the introduction of the panelists for this last session for today. And thank you to the distinguished members of the panel who are joining me today. There are 6 panelists who are joining me in person and 1 panelist joining virtually from Singapore. The topic for discussion is new trends in international arbitration and mediation. Now, this is a very pertinent topic given the challenges that we are facing today, particularly the fact that we are emerging from the COVID-19 pandemic and we are facing many global challenges in geopolitics as well as in macroeconomics. To kickstart this discussion, let me flag a few points, and then the panelists will also comment on the topic. The first point I wish to flag is about the ESG framework. The ESG framework, ESG stands for Environmental, Social, and Governance Framework. Now this term ESG, although it was coined several years ago in a UN report which was titled, "Who Cares Wins?" Basically, the focus is on responsible investment, responsible trade, and expecting businesses and corporates to follow ethical standards and to ensure sustainable development. And I'm aware that the ICC is also focused on this ESG framework, and that's one of the reasons that the ICC was granted observer status by the UN General Assembly. Now you know about the 2030 Sustainable Development Goals, and the UN is very keen on achieving those Sustainable Development Goals. And in relation to that, many organizations are expected to restructure their internal mechanisms to ensure this ESG framework is adhered to. Now, because of that, we see an increase in ESG-related disputes being referred to arbitration and mediation. So we will talk about that during this discussion. The second point I wish to highlight is the Singapore Convention on Mediation. The Singapore Convention on Mediation is like, if you look at the multilateral treaties, it's like the new kid on the block. The Singapore Convention Treaty relates to the recognition and enforcement of settlement agreements, international settlement agreements through mediation. This was brought about, or this came about in 2019, but came into effect in 2020, and Sri Lanka has signed this international treaty. But our domestic law is yet to be enacted. It has been drafted, and very soon it will be presented to Parliament so that we have enabling local domestic legislation so that, we grant recognition to international settlement agreements derived through mediation. The third aspect I like to flag is about the expansion of sectors that are resorting to arbitration and mediation. Sectors such as construction, pharma, then technology, and various sectors are now resorting to arbitration and mediation more and more. And because of that, arbitration and mediation procedure will have to keep abreast with the developments in those sectors and to address the needs of those sectors. Now, having flagged those issues, let me ask the members of the panel also to express their views on this topic that we are discussing, that's the new trends in international mediation and arbitration. May I first ask the representative from CEDA. She's the legal officer and board secretary to CEDA, Chandi Dialvis, to give her views on this topic.
Thank you, ma'am. Good evening to everyone. Yes, I represent the construction industry. So we are also having ADR methods introduced for the construction industry. We are now moving towards the new trends in the ADR. In our, first of all, we didn't have an act. We were first called the ICTAD. ICTAD was now again converted to CEDA by the Act, Construction Industry Development Act, and we became an authority called the Construction Industry Development Authority. In our act, we have given certain dispute resolution mechanism. Before that, there were ICTAD documents, ICTAD bidding documents called the SBDs, the standard bidding documents, where the dispute resolution mechanism was introduced. As the initial dispute resolution mechanism was adjudication. Then the adjudication, both parties select the adjudicator, one member or a panel of 3. When the adjudicator gives the decision, if the parties are not satisfied, they can either go for amicable settlement again, or they can go for arbitration. So the reference of Sri Lankan Arbitration Act is also given in the SBD documents. Now with the enactment of this new act, we have introduced adjudication as well. Before that, before going for adjudication, we have introduced mediation and conciliation. Let me share with you the section in the CEDA Act. In the Construction Development Act, section 50, it says, if the parties so desire, any dispute relating to a contract for construction work, if it is not provided for in the contract, may be settled through conciliation or mediation by the authority. Authority means the CEDA. Before going for adjudication, the parties are free to go for mediation and conciliation. There is a difference, small difference between mediation and conciliation, that is, both are voluntary, and in both mediation and conciliation, there is a third party who is independent, who is assisting the two parties to get together and negotiate. He will not give a decision like in the adjudication or arbitration. But the only difference in conciliation and mediation is, in conciliation, the third party will give a recommendation so that the parties may be obliged to that. But in most of the time, it doesn't happen. So conciliation, in a way, is a failure. But mediation is very effective because it is voluntary and there's no force from anyone. They are getting together and deciding on their own with the help of the third party. So the parties can now go for mediation because of this new introduction in the Act, we are planning to include that in the SBD documents as well. So currently we are doing some guidelines for the mediation. We have studied many international documents as well. Then we are planning to do a regulation in a gazette, giving those guidelines. And we are planning to register mediators. We are going to do training program for them. Then we have a pool of mediators. Then we will have a mediation center with SIDA. And we are going to start mediation because the advantages are many when compared to adjudication and arbitration. Where in most of the time when the decisions are given in adjudication or even arbitration, if the parties don't agree, they will go to the next step in appealing or somewhat going against the decision. They might not comply with the decision. So in mediation, they are getting together and deciding on their own. So it is very effective. That's why we are introducing mediation now. Thank you.
Thank you, Chandi, for those remarks. I know there's a lot of interest amongst you, especially in relation to construction contracts. Now, as you are aware, the construction industry is one sector where ADR is resorted to in a major way. So let us hear from a representative from the CEB, Engineer Anuradha Tilakaratna, who will also give his views on construction contracts.
Thank you, Madam. Good evening to all of you. I think since there are a lot of construction industry professionals in the audience, and I am also in civil engineer, I think I will try to talk much about the construction contract, focusing on this ADR and arbitration. Please, other non-engineering audience, bear with me. I will be talking much about the construction and relating to engineering matters. So first of all, I would like to focus on this construction contracts because we were talking about this ICC rules and other, mainly ICC rules of arbitration and some other local rules called ICLP and so on. But everything can become a success if you if you formulate a proper contract at the beginning of the procedure, because it doesn't come at the end, because when you're drafting a bidding document, that should come into the picture, that you will you should have intention that you will have some problems at the end of the contract. With that intention, you have to draft your bidding documents to enter into the contract. That is the first point. You should have some idea about this ADR procedure and then arbitration procedure. So in order to do that, we have some standard documents. As our SIDA representative mentioned here, we have SIDA standard documents for local contracts. If you are going to draft a contract or set up a bidding procedure, you can directly use this SBDs into your contract. If it is a foreign contract, if it is one party is a foreign party, then they will not agree with your SIDA formula, SIDA SBDs. In that case, you can go for FIDIC, because FIDIC is the globally accepted, well established and very tested for decades, and that is the main set of documents using in worldwide in the construction contracts. So I will little bit explain about this FIDIC FIDIC set of standard bidding documents, because when you enter into contract, you should know what is your nature of your contract. Sometimes you go for measure and pay contracts. Sometimes you go for design and build contract, turnkey contracts, like that. There are certain types of contracts you have to enter into. In that case, the FIDIC has published particular documents to suit with each type of contract. For example, I have brought one copy here. This is called FIDIC Red Book. This is the earlier version, but we have another new version published in 2000s. But this one is the 1987 version. So this kind of standard bidding document you can use for this formulating your bidding documents. Then there will be no problem at the end. And yeah, then what I want to say is you don't want to invent the wheel, because already these documents are there. These documents contain how to deal with these disputes when it arises in the time of executing your contract. I will just go through the arbitration clause here, because the arbitration clause is the most important part. Arbitration clause and both adjudication clause and arbitration clause are the main point whether you can dispute in the process of dispute resolution. These are the most important clause mentioned there. If it is the FIDIC contracts, there's a clause called claim, disputes and arbitration. That clause itself says what are the procedures, what are the steps you have to be taken, and all the things are formulated. Then when people who are drafting the contract documents and bidding documents should be smart enough to take the best opportunity of incorporating these clauses into their contract. And I'm calling about the general conditions of contract. And in the particular conditions of contract, you can include the seat of arbitration, when the place of arbitration, and the law of arbitration, language, and everything you can amend at the general conditions of contract. Then your contract will be smart enough to deal with the disputes you can arise at the time of execution of the contract. Then, having an introduction of that one, I will little bit move into our topic here. Our topic is the trends. Yeah. New trends in international arbitration and mediation. So, I want to mention one thing here, because with the limited time, I will explain it with one example. So, if you introduce FIDIC conditions of contract into your construction contract, then in case of a situation like COVID, for example, during 2019 and 2020 and 2021, we have faced this COVID situation. Because with that situation, we were how to deal with these contractors' claims and everything with this present situation, because it's new to all of us. But FIDIC has given up certain guidelines how to deal with this COVID situation and these things. Then they are supporting us to deal with the new situations, because as Sri Lanka as a country, we don't have such a capacity to formulate such guidelines. But internationally recognized guidelines, these are acceptable for each and every foreign contractors as well. Then if you these are the new things we can adopt from if you follow these standard bidding documents published by the FIDIC. That's what I want to discuss with you. So if you have any question, we can discuss. Thank you very much.
Thank you, Anuradha, for giving us those details in relation to arbitration clauses in construction contracts. And moving away from the construction sector, let me turn to Dayani Kirivattuduwa, Legal Director, UDA, who will explain a little bit about the Singapore Convention that I referred to a little while ago.
Thank you very much. So as our chairperson, SG Viveka Sirivatana said, I am going to talk about little bit about the Singapore Convention. Actually, Sri Lanka in 2019 signed the United Nations Convention on International Settlement Agreements resulting from mediation. This is the Singapore Convention. So the aim of the convention is to contribute to the development of harmonious international economic relations via the enforcement of international settlement agreements resulting from mediation within local jurisdictions. It is appropriate to analyze how the same could be integrated into the legal system of Sri Lanka, along with suitable provisions to promote mediation as an effective mode of alternative dispute resolution. When talking about international commercial mediation, there are merits and demerits. There are many reasons why mediation is preferred by the parties to resolve commercial dispute, like cost, duration, process and procedure, and also mediation is a business environment friendly method. Mediation would guide the parties by refraining issues posing open-ended questions and would use strategies to bypass deadlocks. At this stage, private discussions are held with to all parties to explain those privately. There are certain fundamentals which would have to be put right to ensure that international mediation becomes relating to in Sri Lanka. One is we have to have legal framework to enforce settlement agreements, and also the legal enactments relating to mediation. And infrastructure development also very important in this regard. Sri Lanka has taken first step to promote international commercial mediation as a potential ADR method by signing the Singapore Convention. However, much needs to be done before the convention can be given effect if Sri Lanka were to become an international center for alternative dispute resolution initiatives. The Singapore Convention has provided Sri Lanka with a fresh opportunity to develop the country as a hub of mediation in the South Asia region. Thank you.
Thank you, Dani, for that brief introduction of the Singapore Convention. Now I turn to Engineer Mr. Surya Bandara from the Road Development Authority to express his views on this topic.
Thank you, Madam. Good evening, ladies and gentlemen. Since I am also from the construction industry, I too agree with my early colleagues. Construction, of course, we are widely using two types of documents. In the case of local construction contracts, we have our SIDA documents. We already developed 4 types of documents: small, medium, and large contracts, as well as design and build contracts. If we go to the international contracts, widely we are using predict condition of contracts. Depend on your project, you can choose different predict books. If it is a measure and pay, you can use predict red book. I think I want to correct one thing. Very recently, predict update, they have predict red book 2017 one also. And if it is a funded project, we can use predict pink book. Multilateral Development Bank, they get together and develop another book called Pink Book. If it is a design and build, you can use yellow or silver book. If it is investment project, we can use gold book. All these documents, FIDICO, SIDA, they all recognize alternative dispute resolution systems. Why they choose this system? Because of the complexity of the industry, knowledge of the subject. Therefore, we have identified these two documents, they have identified arbitration as well as adjudication. Extended version of adjudication, in the mega project, they have introduced Dispute Adjudication Board. Dispute Adjudication Board means they are with us on call throughout the construction. They are visiting to the site, identify the problems. Through that system, when there is a dispute between parties, they can solve it with the acquired knowledge. That system is there. Some projects we used that system for settle the disputes. Sometimes we are using ad hoc arbitration or the adjudication. Some cases we are using institution arbitration too. I will tell one thing about the adjudication or the selection of arbitrators. I prefer if you can go to the nomination body. SIDA, they have a list of arbitrators, adjudicators. ICCSL, Institute of Engineers Sri Lanka, they have list of arbitrators, adjudicators, and some other professional body too, they have their list of arbitrators, adjudicators. Why I am telling this one? The thing is, if you take building construction, we have different fields. Maybe if it is on a file foundation, filing part is there. When there is a dispute between contract and the employer with regard to the foundation, best person to solve your problem is the foundation expert. When you come up with a building, there may be a problem in the electrical system or the mechanical systems. Then best person to solve your problem is electrical person. Therefore, if you refer the particular case to the particular institute, maybe ICCSL or SIDA, they will give you the most suitable, capable person to solve your problem. They will give few names to you, then you can choose. Both parties can get together and choose one or maybe three, depending on your agreement. Therefore, friends, now I want to add something about the present tense. Now we are moving to the public-private partnerships also. We are inviting investors to come and do the infrastructure project. It means our agreement should be bankable. Because in the case of private-public partnerships, these private investors, they don't use their own money to do the construction of maybe a road or whatever structure. They are also getting funds from the banks. Therefore, our agreement should be bankable. Then the banks and the investors, they are not happy to follow our litigation procedure. They want to solve their problem as early as possible without delaying the things. Therefore, they are happy to have introduced things like arbitration, especially in the case of international arbitration like ICC arbitration into the agreement. This is the present trends related to the current PPP system. Having said that, I'll conclude my these things, and if you have any questions, feel free to ask.
Thank you, Senior Engineer Mr. Surya Bandara, for those very useful comments. And let me now turn to Tejas Chauhan, Regional Director for South Asia ICC, to give his views on this topic of new trends in international arbitration and mediation.
Thank you so much. Last session, the energy is low, and you've already heard me before, but again, I seek your indulgence. Very general question and a very general topic, but I will give the international perspective and also what we see at the institution. We spoke about FIDIC. One of the recommended templates in FIDIC is ICC arbitration as a dispute resolution mechanism. What we see is that sometimes we are also very creative with those clauses, so we don't stick to the general clause. We remove ICC, we add another institution, or we keep ICC rules and add another institution. So for all the construction lawyers, please do not do that. Construction is here to stay, and construction disputes are here to stay. In 2021, construction made up for the largest share of disputes that the ICC received, followed by energy. So 40% of our caseload actually comes from the construction and energy space. We spoke about mediation, and we've been dealing with ICC arbitration. We've been speaking about ICC arbitration, but mediation is something that we see work. In fact, in one of our discussions earlier, I was mentioning that it's not just for small value disputes, but mediation also works for large value disputes. So you have parties agreeing to mediation and then getting into arbitration, but they don't have to get into arbitration at all. Or a lot of parties prefer mediation. This is also helpful because you want to preserve relationships. So a lot of parties think that having a dispute board or mediation would be helpful. So ICC has mediation rules and the dispute board rules, which is a topic for another day. We spoke about third-party funding briefly in the international context. Again, that is something which is seen. The legality of it and jurisdiction, all of that is a consideration, but something that you can look at, because many a times parties do have claims which are based on merit, but they do not have the funds to back those claims. And that is where third-party funders come in, who will take a certain share, a percentage, and fund your litigation or arbitration. So preliminary thoughts that I had that I wanted to share.
Thank you, Tejas, for those comments. And let me now turn to my colleague from the Aegis Department, ASG President's Counsel, Susantha Balapadamadi, to give his views.
One of the concerns that I have, especially in relation to this construction industry, is the FIDIC has its incorporated dispute settlement mechanism, one of this DAB, Dispute Adjudication Board. Now, the FIDIC rules, as you know, drafted by Risa Becker on behalf of the FIDIC. And even week before, she had a session in Dubai with the department officials, a training session. One of the observations that she has made at that session was that the DAB system, although it's embedded system in the FIDIC, has not given enough the expected results. The construction industry has taken up the position that it is an additional cost to the contractors. For the reason is that you have to go for DAB to resolve the dispute, not a resolution as such, it's an interim resolution mechanism before you proceed to the next step. And the construction industry invariably incur cost twice. So, Risa Becker has suggested that they are revisiting the FIDIC rules. For the reason is that 90%, more than 90% of the disputes, although you have a DAB system, dispute adjudication system, finally ended up in arbitration. So this is an additional cost to the contractors as well as to the employers. So I don't know to what extent that the DAB system has worked in Sri Lanka and whether there was any study by the CEDA in relation to the DAB system. Whether it has worked out in Sri Lanka, whether all the disputes finally end up in the arbitration. That I don't know. So whether the DAB system works effectively in Sri Lanka or not is a question mark. In my experience, the answer is no. Okay. So that is one of the concerns that I have it. Now with regard to this mediation, I don't know whether anyone in this audience has any experience in international mediations. I have only very limited experience in international mediations, and we need to get ourselves trained in mediation. Although we are counsel, the role that we play is completely different to the role that we play in mediation. And the role of the mediator is completely different to the role that the arbitrator plays in the mediation. I have only one experience in international mediation, which I had it in London at the Clyde & Co head office in one of these charter party agreements. We had an arbitration clause in our agreement, and both parties decided to have one round of mediation and see whether we could resolve that disputes, and we decided to have that at Clyde & Co building head office, with the Clyde & Co was the lawyers for the charter party, and I represented one of these state institutions, and how it works is completely different to the arbitration process. So we need, now, as A. Viveka Sirivardhan correctly pointed out, very soon the Mediation Act, International Mediation Act, will be a reality. And whether we are trained enough to resolve the disputes through mediation is a huge, big question mark. We as lawyers, we are litigators, and we have the same approach even when we go for arbitrations. Although there's a lot of similarities between arbitration and the litigation, but the mediation is completely a different process. With my experience, it's a completely different process. We need to have qualified mediators. I know for a fact that our department has trained few mediators in the Malaysian Mediation Center. There are few people who have got the qualifications as mediators, but I don't know whether the private bar has enough counsel who are trained in mediations. We have to be ready once Act is in place for international mediations. Now, Chegas mentioned about third-party funding. As you know, even in the ICCSL has now amended the rules to give effect to third-party funding. Sri Lanka is a signatory country to ICCSL. And as you may know, the UNCITRAL has 5 working groups, ongoing working groups, to come up with the model laws. Working group 3 is on ISDS, Investor-State Dispute Settlements. Working group 3, the discussions are going on. Sri Lanka is also participating in the ISDS mechanism. I was the representative of Sri Lanka in first few negotiations in New York and Vienna. One of the challenges that we had in that negotiation was, when it came to third-party funding, was that our local law does not permit contingency fee arrangement. As you know, this is quite popular in other parts of the world. We call it no-win, no-fee arrangement. It is a part of the contingency fee arrangement. No lawyer can enter into an agreement to take part of the judgment in Sri Lanka. I will appear for free of charge, but once the judgment is given, I want 50% of that. That is unethical as at today from the Sri Lankan perspective. So when you go and enter into a third-party funding in international agreement, and when it comes to enforcement, the public policy is still a ground to set aside the arbitral award in Sri Lanka. India has moved away from that, and fraud is only ground. But as at today, public policy is ground to set aside the arbitral award. So when the contingency fee arrangement is not allowed locally as a public policy, and when they enter into a third-party arrangement, third-party funding arrangement, and once the award is made, and if you want to give effect to that, or when you want to enforce that award locally, in local courts, this becomes an issue. So how do you give effect to third-party funding as at today in Sri Lanka legal framework? That's a huge challenge. Sri Lanka being a signatory country to ICCSL, and ICCSL has amended the rules to incorporate third-party third-party funding. Even the UNCITRAL new model law, which is going to come out in Working Group 3 discussions, most of the countries are in favor of the third-party funding, subject to certain limitations. But even subject to limitations, whether the Sri Lanka can agree or not. It's a huge policy issue. So unless we moved away from this contingency fee arrangement, which is unethical in Sri Lankan law, we are unable to give effect to third-party funding. So how are we going to give effect in Sri Lanka in third-party funding arrangement? So this, some of the concerns, although it's with the topic that we have is trends. Third-party funding is a new trend. If you are an investor who has invested in another country, but you are unable to get into ICCSL dispute settlement mechanism, for the reason is that you don't have sufficient funds to get involved in international arbitration, you can get another party to fund for you, but provided the party who funded for the arbitration will get a certain percentage or the full award. So that is not permitted in our Sri Lankan legal framework. So these are some of the challenges that we have it. We need to revisit these things as a policy. These are, as of today, it's unethical. It's not permitted. We all know that we cannot enter into an agreement with our client, even in a personal injury case, that in the event if I get a X amount of as damages, you have to pay me 50%. That is considered to be an unethical practice. So with that in mind, how are we going to give effect to third-party funding in Sri Lanka? Although it's internationally now accepted trend. So those are some of the thoughts that I have it, and I will express any other views in case if somebody wants any further questions.
Thank you, Susanta, for sharing those insights with us. Now, let us hear from the panelist who is joining us virtually from Singapore, Mr. Anil Changaroth, who is the co-head ESG practice RHT Law Asia, Singapore.
Can you all hear me? Can you all hear me there?
Yes, we can hear you.
Okay. Thank you so much. I'm very sorry I can't be there because I am actually due to be in Sri Lanka from the 21st to the 27th of August for investor state mediation competition and some presentation. So I can't make the 2 trips. Now, thank you so much for Chanel for inviting me. I'm going to do this. I know it's very late in the evening, so I'm going to do this in 2 portions, 3 portions if possible. The first portion is I'm just going to address some points raised by my panelists, following which I will then address the key points that our Madam Moderator has highlighted about ESG and the Singapore Convention, right? And then if time permits, I'll just speak a little bit very fast on blockchain, smart contracts, and litigation funding if time permits. So bear with me. Let me just start with a lady from Madam Chandi. I do apologize if my pronunciation is bad. She spoke about the construction industry. 50% of my work is related to construction industry. I sit as a mediator, arbitrator, adjudicator, dispute board member in Singapore and in the region. In fact, on dispute boards, I'm the Singapore regional head of the DRBF. DRBF is the Dispute Resolution Board Foundation. Right, and so I'll speak a little bit about that. And when she spoke about construction industry and she talked about dispute resolution mechanisms, she highlighted the fact that conciliation and mediation is part of the system that they have in place. And she also spoke about adjudication. Now, you have to appreciate the panel before, there was a gentleman who also spoke a little bit about adjudication, I believe. Adjudication is a regime that's a very fast-track method of dispute resolution for the construction industry. I believe your CEDA has it in a contractual mechanism, but in many countries around the world, UK, Singapore, Malaysia, Australia, New Zealand, and Ireland, it is a statutory regime, right? So that's a discussion is for another day, because I can speak at length at that for an hour or two on just on adjudication. But the crux of what she said is this: even for the construction industry, there are so many dispute resolution mechanisms available. Right now, many of you throughout the day referred to it as alternate dispute resolution. I haven't used the term alternate for over 10 years. I use the term appropriate dispute resolution because, in all honesty, the world has changed so much that we are now talking about what is the most appropriate method of dispute resolution, not alternate to litigation or arbitration. So that was the First Lady's comments. Next, Mr. Anuradha had spoken about formulating proper binding contracts, right? Absolutely agree with him. I think it's the starting point is on procurement, how you procure a contract, right? And it's actually quite critical that you try and have people working together. And that's a new concept called collaborative contracting, right? That's also another topic. I am due to present in Turkey in October on collaborative contracting. In Singapore, we have a conference coming up in September, also talking about collaborative contracting, how people are there to work together, not working as you take the risk, I don't take the risk, you bear all of the risk and all of the financial losses, but I don't do that. But the world is also changing, arising out of what our moderator had said. The circumstances of the world post-COVID has become so, it's all-encompassing. It affects everybody, so you've got no choice but to try and work together, right? Then Dayani from the UDA spoke about the Singapore Convention. I'll be speaking about that in my presentation a little bit later, right? And then Mr. Surya, I think you spoke about two documents in the CIDA. That means the contract forms, the forms of contracts that you have available in the construction industry. In Singapore, I have advised the Singapore Institute of Architects on their form of contracts, and we've developed contract forms that are adapted from international contracts like the FIDIC contract. There's another contract called the Joint Tribunal contract. So you have to look, in your industry, you may want to take a look at the possibility of coming together and putting your own form of contract that encompasses international contracts and takes into account all the best practices in those systems. Tejas, you spoke about, Tejas, my dear friend, spoke about FIDIC using ICC. I will talk about, and he said, please do not take out the ICC clauses. In my slide presentation, I'll talk a little bit about why the ICC form of dispute resolution mechanism is really helpful, and it can do a lot of good. He spoke about mediation and third-party funding. Now, some of you may not realize what third-party funding is, but let me just quickly in one line explain to you. Third-party funding means investors put money into a litigation funder, right? And parties that want to take out a claim and they don't have sufficient fund turn to the litigation funders. The litigation funders will assess the case and see whether it's a viable case for them to be supporting. They provide the funds for the claimants to go and fight the case. If the claimant succeeds, the funders get a percentage, obviously, because they cannot make a business out of it. So that's what third-party funding is about. I'll mention a little bit more on our dear Attorney General's Chambers gentleman who spoke a little bit about that. So these are the 3 points that Tejas highlighted. Now, the gentleman from the AGC, I'm very sorry I didn't get your name, but you spoke about dispute adjudication board, right? Like I said, I am the Singapore rep for Dispute Board Organization, international organization. I just came back from Jakarta for a conference on dispute boards. How dispute boards work is very simple. From the start of the project, they have a team of either 1 or 3 people sitting there. And every 2 months or so, whenever there's a problem, they look at the documentation and they give recommendations. They can either give recommendations or they can give binding decisions that the parties are bound by. And you find that by the end of the project, none of the parties would go to court, none of the parties would go to arbitration. So there is a lot of benefits from dispute board. That again is another topic that I can take quite some time discussing, but I'm not going to do that, right? So having just shared my views on the panel, let me now just come back to what the moderator had highlighted. Challenges of the world, ESG framework, and the Singapore Convention. And with that in mind, can I just share my slides and I will then explain to you what I have. all right, both on ESG and the Singapore Convention, right? And here we go. All right. Sorry. Okay, let me see whether you can see my slides. I hope you can see my slides, and you probably see me on the face as well on the slides. So I'm going to speak to you a little bit about environmental, social, and governance. As the moderator kindly mentioned, I'm the co-head of the ESG practice group in the RHT Law. But more importantly, I am the new chair of the Law Society of Singapore's ESG working group. And we are about, in a month's time, about to announce incredible things that we're going to launch to get lawyers trained in ESG, not just lawyers, but also accountants as well, right? But that's again another topic, right? So I'm just going to speak a little bit about ESG and ESG disputes, and I'm going to speak a little bit about the appropriate dispute resolution mechanisms, both the Singapore Convention and the ICC's effective conflict management, because at the end of the day, today we are here because of ICC, and I think it's really important that we highlight some things about ICC. Now, I'm going to be doing this really fast, but you're going to get a set of my slides, and the slides would have hyperlinks that will guide you to it. Now, the Madam Moderator so kindly explained the fact that ESG is something that's been said a long time ago. It was our United Nations Secretary General. He said that these principles grew out of the understanding that while finance fuels the global economy, investment decision-making does not sufficiently reflect environmental, social, and corporate governance considerations. So 18 years later, we are now in the center of this ESG idea and concept and everything else. It really stems from the UN Sustainable Goals. There are 17 goals, and a lot of the ESG elements comes from all of these goals, all right? What it basically means is ESG is a set of standards for the company's behavior used by social conscious investors to screen potential investments, right? So if you're talking about environmental issues, you've got the climate change issue, which the United Nations Secretary General just announced the fact that the world is no longer critical because it's boiling. Right? Social issues, you have diversity, equity, and inclusion, employee relationships, and all that. And governance, you have a whole lot of rules and regulations that you need to comply with. Now, the kind of disputes that can come up from ESG is climate change, combating abusive supply chain practices, whether or not you're being a responsible business commitment, whether you carry out a code of conduct, whether you have adverse human rights and anti-discrimination rules, and whether or not you have complied with international and domestic regulations. For example, international regulation would be the new EU regulation on sustainability, all right? Now, again, the kind of disputes that can arise, you can have cross-border commercial contract claims that are not in compliance with ESG requirements. They are investor-state treaties based on disputes. I, by the way, have been trained on international investor-state both arbitration and mediation. I've been trained for it internationally, and I do deal with some of those issues. So you can have investor-state disputes that arise, and then there have been a lot of treaties that have also had serious problems. Now, all of this material, this pointers that I've highlighted, actually come from an ICC report that was made, right? Resolving climate change-related disputes through arbitration and ADR. And in that report in 2019, they highlighted some of these serious problems. Okay, I go now to Singapore Convention. I know our speakers have spoken a little bit about it. If you go and click on my slides, it'll take you to the convention and explain what it is about. It's an enforcement mechanism of an internationally mediated settlement, right? So there are certain critical elements. One party must be international in some nature, but when it's settled, and if one party fails to comply on it or fails to pay up, you can take up enforcement proceedings. So effectively, the Singapore Convention is similar to what the New York Convention does for arbitration. That's what the Singapore Convention is. But many people who, if you really understand the core of mediation, you will realize that if you have a mediated settlement, you don't really need to worry about enforcement, because the other party is not really going to default on it, all right? These are some of the articles in the convention. And it's really quite important that you get these things paid attention to. Now, I think one of the speakers somewhere during the day had, I'm not sure whether it's in this session, but highlighted the part about proper training. It is really, really critical because I know a whole lot of people on LinkedIn call themselves mediators, but they're not trained. The mediation is in absolutely different culture from arbitration. I first spoke about it in Sri Lanka close to 10 years ago when I was dealing with a developer there. And I recommended mediation. 2 years later, when I met him again, he was still in arbitration. 4 years later, when I met him again, he was still in arbitration. But that matter could have been resolved by way of a mediation. So it's a really different set of skills. You need to be trained in it. I had I assisted the US State Department in a mediation training about 3 years ago in Sri Lanka. So it takes a different skill sets for that, all right? Now the ICC, coming to my last point, the ICC's effective conflict management, right? They have all of this. Before the conflict, what they can do, during the conflict, and eventually arbitration. So go take a look at that, really quite effective. And again here, these are all hyperlinked so you can see them. The ICC dispute resolution services include ICC arbitration administered by the International Court of Arbitration and ICC ADR services, right, administered by the ICC Center for ADR. So you have a clear regime that deals with arbitration and mediation that you can turn to. So, you know, if you're in an organization, you're not sure where you want to go to in your dispute resolution mechanism, please, I beg you, just go take a look at ICC and what they have offer you, because it is all encompassing. It deals with all aspects. I believe they also have a dispute avoidance mechanism in place as well. But take a look at it, take a look at my slides and you have that guidance, all right? It can be used as a standalone or it could be used conjunctively with other aspects as well, all right? So again, the ICC's effective conflict management guide includes mediation, expert proceedings, dispute boards, and a whole lot of others. That again, the regime of dispute resolution can start from conciliatory measures like conciliation, negotiations, and mediations, and it can then go to adjudicative, meaning someone else making a decision. You have neutral evaluation, expert determination, dispute boards, conflict avoidance board, adjudication, arbitration, and litigation. So that's a whole set of rules that you need to understand and appreciate. But the essence of what ICC is doing is that it's giving you a whole array of dispute resolution mechanisms that you can consider. And, oh, sorry, I think I spoke about this, and that's it. On my slide, I'll just stop sharing. I know it's a very quick, fast run, but I appreciate that many of you it's very late in the evening, so these, you know, appreciating and understanding some of these concepts are going to be taking a little time. I thought I'd just say one or two last points because there was a session earlier on when they spoke about blockchain and smart contracts. So just so that you understand, blockchains are digital database or ledgers that distribute among a node or a peer-to-peer network. So that means you have a document that has got a code, it is tied to another next document and so on, and each of those documents cannot be amended and changed because they come with a code, and it forms a block in a chain. And that's what the people talk about blockchain. Smart contracts are self-executing contracts with the terms of the agreement between the buyer and the seller being directly written within the lines of the code. So it's coded, it's online, and it's also a fast method of getting your contracts out, but secured, not amended or adjusted, right? And that's it. So what I've done is I've just shared my views about what my panelists have said. I've shared the critical points that our moderator had highlighted about ESG practice and the Singapore Mediation Convention. But I also highlighted what is critical about ICC. Thank you so much for that. Moderator, I'm back to you then.
Thank you, Mr. Chandragot, for your presentation and sharing your thoughts on the various aspects that were flagged, including the Singapore Convention and the ESG framework. Now, you have listened to all the panelists, So now I will open the floor for discussion and questions. You can pose your questions, please.
Yeah, can you hear me? Yeah. Mr. Balpan raised an interesting point. He almost said that the adjudication is a more or less a waste of time and money, because anyway it has to go through arbitration. Yes, true in Sri Lanka, because we are so backward in our legal system. Rest of the world has already solved this, starting from UK. If you look at the UK Adjudication Act, UK has an Adjudication Act. They can directly go from adjudication decision to courts. You don't have to go through the arbitration. In fact, almost all the Commonwealth countries have accepted that. So before we are thinking of introducing mediation, I think we must get the adjudication enacted. Let the adjudicators with all due respect to the others, adjudicators are more equipped because they are industry experts to resolve a dispute and find out what has to be done, what to make a decision. So the UK provides it. They can go to, in fact, the statistics, latest statistics I have read, said that 95% of the industry, the construction industry disputes are resolved at the adjudication level. Very few go for litigation. Because at the adjudication also given the fair amount of authority, the courts, you go to courts to get it enforced. So I think we have to think of that seriously. In fact, the last speaker, he mentioned that. That's it. That's what my comment is.
Madam Moderator, could I share a couple of points on that, please?
Yes, certainly. Go ahead.
Right. Thank you so much, sir, for that comment. But I don't know whether or not you there's a slight distinction. The adjudication that you are speaking about is the adjudication in the construction industry, right? I think Chandihi had mentioned that as well, in the construction industry. So the adjudication regime in the construction industry, like for example, in Sri Lanka, I believe it's contractual, whereas in England, Australia, New Zealand, Singapore, Malaysia, and Ireland is statutory. That is a very fixed set of timelines, very short timelines, and it's very fast that you decide. Whereas our dear Mr. From the Attorney General's chamber, what he was speaking about is dispute adjudication board. And that's very different from adjudication in the construction industry. Dispute adjudication board, as I mentioned to you, is a group of people that are set up in the start of the project just to deal with disputes for the project. Now, the AGC gentleman also highlighted the fact that it can be expensive. The reason for that is if you have a standing adjudication board, you have to pay the three gentlemen every month, even if they don't do anything, right? And that's why he said it can be expensive. But you see the FIDIC and all of that have got what is called a dispute avoidance and adjudication board, right? So they have developed it into a regime where it can be recommendations that they give, or it can be decisions that they can give. Now the decisions obviously can be challenged, and that might end up in arbitration. And that's why he said you might end up with two mechanisms used. First, the dispute board, and once one party is not happy with that decision, it goes to arbitration, or it can go to court. But the same can actually also happen with arbitration. With arbitration, when there's a decision, parties would challenge it and they go to court as well. So therein lies the difference. The adjudication that you're mentioning is for the construction industry. It's either contractual or statutory, whereas the panelist discussion on adjudication is the adjudication board, which is a different regime altogether as well. Thank you.
Thank you, Mr. Changarod, for your views on that comment that was posed by a member in this audience. Any more questions?
Yes.
Yeah, over to you.
This is not a question to Mr. Anuradha CEB. FIDIC 87, you said you are using 87, 99, 2017. It is much more practicable than the 87. 87 time is, I think, over. The other one is, as Mr. Anil Chandraghosh, as he said, ESG. ESG, so many environmental regulations and act and something referred in our contract document, we have to put in as the law, like the Singapore, say, what the ESG practice into our contract document. It is mentioned, something mentioned indirectly, mentioned, but it is particular practice in detail, it has to incorporate to our CEDA documents. It is something given. The other thing is, this, what do you call this, obligation. The other one is what do you call this, when we refer to the arbitration, we clearly mention Arbitration Act number 11, 1995. But other adjudication act or anything, adjudication or the mediation, it is a problem. Right? Therefore, if we have adjudication act in Sri Lanka or the mediation act in Sri Lanka, if not, we have to pass to the parliament and incorporate it into the documents. It is very clear. Otherwise, people used to write as they like. So many things about the adjudication and the mediation. No, it must be converted as an act. Those are my suggestions.
Would Mr. Anuradha be saying something about his first point, because I'll speak about the rest of his points as well.
Mr. Anuradha, I think he has a comment.
Yeah, as he said, I didn't say I'm using this one because at the moment I have only a copy of this 89 version of the Red Book. I just wanted you all to, I wanted to show you all what the Red Book is. That is why I said I brought the earlier version, then the latest version also in place. Then anyone who want to use that, it's available in the FIDIC. And I want to add something to Mr. Susanta's one. But as most of the government, state sector projects, the reluctant point, what we are not going for the adjudication is the funding problem. Because we don't have enough money to fund for these adjudication boards and maintaining this retaining fee and sitting fees and everything. Then in case of this foreign funded project, they have allocated a certain sum of money for this adjudication process. So at the time of preparing the estimate, if we can add some amount allocation for this one, they agreed. In that case, ultimately we are paying it back to the funding agencies. So in that case, it will not become a problem of this. The public policy issue will not arise, I think. No? Then in that case.
I have been informed by the organizers that the time is up for this discussion, so I'm afraid I cannot entertain any more questions or comments. So thank you very much. It has been a long day, but I hope it has been a useful session. A very brief comment from Chandi, very short.
Just to say that the public policy issue was discussed in relation to third-party funding, not in relation to the dispute adjudication board. So I wanted to make it very clear to Ms. Anuradha.
Yeah.
Adding something to one of the members of the audience said, now, yes, we don't have a statutory adjudication in Sri Lanka is not there. we only have contractual adjudication because it arises from the conditions of contract. What SEDA actually tried to introduce a statutory adjudication by enacting an act. While it went to the cabinet, there was an objection from the finance ministry because at the time the government policy was such that it will not allow such payment act because it is something similar to the SOP Act of the Singapore.
Yes.
At that time there was an objection from the government. So today I was discussing this matter with the legal officer of the port city. What she said was now the policies of the government has changed, so we might try again to introduce this act.
Let me wind up this session by thanking all the panelists for sharing their views and insights. And as you are aware, the ICC Court is celebrating its centenary year this year. And let us hope and wish the ICC another 100 years of success. Thank you.
Thank you. Good night.
Thank you, Madam. Thank you to all the members of the panels who are here today for their esteemed insights and their contributions. On that note, we would like to once again ask Mr. Tejas to take the stage, please, to accept a small token of appreciation for being a part of this invaluable event to the ICC Sri Lanka, to the legal community here in Sri Lanka. And to mark the end of today's event, please invite Mr. Hemakumara Gunasekara, the Secretary of the ICC Sri Lanka, to deliver the vote of thanks.
Thank you, Purnima. Good evening, all distinguished guests. At the end of a very successful conference, it's my duty as a Secretary of the International Chamber of Commerce Sri Lanka to propose a vote of thanks. So, first of all, I would like to extend my sincere thanks on behalf of the organizing committee to the Honorable Justice Priyantha Jayawardena, Judge of the Supreme Court of Sri Lanka, who were present here in the morning session amidst of his busy schedule. And Mr. Vikumdi Abru and Mrs. Viveka Sirivardena, both are the additional Solicitor Generals. They are here. Mrs. Viveka, still here from the morning. Thank you so much, and I would express my gratitude to both of them. And Dr. Harsha Cabral, President Council, and Mr. Dinal Phillips, the present member of ICC Court of Arbitration. Thank you so much, sir. Mr. Chandana Liana Patamadi, my friend, the President Council, you're also here from the morning. Thank you, Chandana. And Mr. Anand Maju Mudar, an eminent lawyer from India. He was here. Thank you, Mr. Anand. And special thanks goes to Mr. Tejas Chauhan, the ICC Regional Director for South Asia. Thank you, Mr. Tejan. His first visit to Sri Lanka, though he is the next door man. Hope that you will be here with us in our future events. Then I have to thank all the people who joined us virtually. Mr. Dato Jude Benny, who has been with us for a long time, a good friend of our chairman. He had been here earlier. And Mr. Murali Panni and Anil Chandragoth, all are eminent arbitration lawyers from Singapore. And young man is Yasit Hirmuregama from Finland, who represents the YAAF. Thank you very much, all of you, for joining us virtually. And I have to thank the panel members, Mrs. Himali Orogodavatta, Director, Chief Legal Officer, BOI, and Mrs. Vindhya Veerasekara, Legal Officer, Colombo Port City, and Mrs. Himali Manatunga, Manager Legal, Ceylon Bank, Mr. Naveen Pereira, Assistant Vice President, Group Chief Legal Officer, Aitken Spence, Mr. Roshan Madarasinghe, Director, Contract Administrator, Maga Engineering Private Limited, Mr. Anuruddha Tilakaratna, Engineer, Project Manager, Maragolla Hydropower Project, Ceylon Electricity Board, Ms. Dayani Kirivatudua, Legal Director, UDA, Mr. Chandidi Alvis, Legal Officer and Board Secretary, CEDIA, and Mr. SMP Surya Bandara, Senior Engineer, Road Development Authority. Thank you very much for all, because without you, we could not make this event success. And finally, I have to thank all our sponsors, namely Aitken Spence, Colombo Stock Exchange, DEMO, NDB, OTR Wheel Engineering, Printcare, Tyan Lanka, and our media sponsor, Daily FT. Without their sponsorship, we would have to struggle to make this event. And at last, not least, I have to thank Mr. Ruwan Senanayaka, who helped us in digital arrangements and the ICT facilities, and Ms. Kishani and the Uber Minds, the digital media partner of ICC, and the Mr. Sampath Sirwadana, General Manager of Galadhar, and his staff, who has arranged everything for us. And the board members of ICC and the staff of ICC should be mentioned, and I express my gratitude to them too. And hope that we will have another fruitful event next year. This is our second one. Last year we had third one. Last 2 years we had the same sessions or the seminars, and hope to organize a better one next year under the leadership of our chairman, Mr. Chanil Fernando. Thank you very much again, and have a nice evening.
Thank you, Mr. Gunasekara. Before we conclude, ladies and gentlemen, we have one final announcement. Everybody who registered for today's event is eligible to an e-certificate, which will be sent to your email addresses. So please do contact the ICC Sri Lanka office and ensure that you have shared your details, including the name that has to appear on the certificate. And on that note, thank you, ladies and gentlemen, our distinguished guests, our special invitees for attending today's event, and we wish you a pleasant evening. Thank you.